in this session. So welcome I'm Stuart Oppenheim with the Child and Family Policy Institute of California, and it's my pleasure to welcome you to our second session of growing and linking our knowledge about data, history, and sovereignty to strengthen ICWA practice and CPM leadership behaviors. Our learning objectives are to learn about state and counties' responsibility to engage in government relationship with tribes in child welfare matters, to learn about the concepts and features of ongoing tribal engagement and consultation, and to deepen the understanding of the role of child welfare leadership in the application of the Indian Child Welfare Act. So as I've asked all of you to do a land acknowledgement, I'd like to begin today with my own land acknowledgement. I'd like to begin by acknowledging that for 5 generations, my family members have occupied the unceded ancestral homelands of the Yelamu, a tribe of the Ramaytush Ohlone peoples, who are the original inhabitants of the San Francisco Peninsula. We wish to pay our respects to the ancestors, elders, and relatives of the Ramaytush community, and to affirm their sovereign rights as First Peoples. We honor the Ramaytush Ohlone for their enduring commitment to steward this land. We recognize that the Ramaytush Ohlone have never ceded, lost, nor forgotten their responsibilities as the caretakers of this place, as well as for all peoples who reside in their traditional territory. That they have lived in harmony with nature for millennia, and that to achieve a truly ecologically sustainable future for San Francisco, we must embrace indigenous traditional ecological knowledge and how we care for the city's lands, waters, and all its peoples. And again, something that all of you will do, maybe not as elaborate a land acknowledgement, but do a land acknowledgement in the chat. It's an important way to begin not only this session, but all of our sessions. So I'd also like to acknowledge that November is celebrating Native American Heritage Month and 43 years of the Indian Child Welfare Act. Native American and Alaska Native Heritage Month has evolved from the beginnings as a week-long celebration in 1986 as American Indian Week. Every president since 1995 has issued an annual proclamation designating the month of November as the time to celebrate the cultures, accomplishments, and contributions of Native Americans and Alaska Natives. So wonderful that it's evolved from just a week to an entire month. And also to acknowledge that this is 43 years of ICWA. I think I will acknowledge that I've been doing this work in child welfare since the time of the passage of ICWA, and I think it's our collective responsibility to acknowledge that although it's been this amount of time, we have yet to fully implement ICWA, and it really is a moral, ethical, and legal responsibility that we take seriously the work that we're doing here and make sure that we don't go another 43 years without fully implementing ICWA, or another year without fully implementing ICWA. It's a time, but this month is a time to celebrate rich and diverse cultures, traditions, and histories, to acknowledge the important contributions of Native people. It's a time to educate yourself, your staff, your family, and community about tribes, to raise a general awareness about the unique challenges Native people have faced both historically and in the present, and the ways in which tribal citizens have worked to conquer these challenges. And again, to think about ways that we can join arms with tribal people to make sure that we realize a truly equitable system. So with that, I'm going to tell you who's going to be our presenters today. A great group that's worked tirelessly behind the scenes to bring you this great presentation that you're going to see today. Our presenters are Stephanie Weldon, who is the newly appointed Office of Tribal Affairs Director for the state of California. Sylvia DePorto, who's part of our CFPIC core practice model faculty. Jennifer Parsons from the Office of Tribal Affairs. Jessica Fawn-Canez of the Office of Tribal Affairs. Donald Rodriguez from the Office of Tribal Affairs. Andrea Sobrato, who's our new CFPIC Associate Director. Jennifer Buchholz from the Bay Area Training Academy, and Leah Lujan, the Consultant General Training Academy. So with that, I am going to turn it over to Sylvia to do a brief review of our agenda for today.
All right, thank you, Stuart, and good morning, everyone. We're just a quick review of our agenda today. We're in the middle of the welcome and the overview. We're going to recap and dive a little deeper into tribal sovereignty. Last time we talked a little bit about tribal sovereignty. We're going to dive a little deeper into that and give you some more detailed information. And then we're going to talk about contemporary tribes and what that looks like in our current setting. We have a panel presentation this morning with 3 county leaders and 3 tribal leaders from different areas, from northern area, central area, and southern area. So we'll be asking them some questions about their partnership and their engagement. Then we'll talk about tribal engagement and consultation and what that means for you all coming from the counties. And then we have a poll and we'll take a break. We'll debrief that poll briefly, and then we're going to give you a great deal of information about the Office of Tribal Affairs, and then start an ICWA overview. So you have an understanding of the Indian Child Welfare Act and some of the changes that have happened over the last couple of years with the Indian Child Welfare Act. And after that, we'll be closing and preparing you for our 3rd and final session for the ICWA overviews, or the ICWA sessions, I'm sorry. Okay, next slide, Stuart. So just a recap, building from our first REI session on the Indian Child Welfare Act and ICWA and Native Americans in general, we had that session on August 1st. And following the regional session, we had some interim sessions that we called 1.5. So that was our first session that we had. And we talked about what was the current data telling us about Native Americans in the child welfare system, and what was it not telling us? And what was it not or telling us about the disparities that exist for our Native American children and families that we're serving in child welfare? We also talked a lot about the historical context of the Native American experience in the United States and in California, so that you would have a deeper understanding of some of the history of this country and government intrusion into Native laws and their own governments. We introduced those government laws and practices that shaped and impacted Native American experience, especially as it pertained to children and families. So we learned a little bit about the boarding school era, the relocation era, the termination era, the Indian Adoption Project. All of those were government laws and practices that really had an impact on Native American people in the United States. And then we had the regional training academies had conducted interim sessions in which the directors were asked to bring their own data and to meet with their field liaison. The Office of Tribal Affairs has field liaisons, and they were part of those sessions so that the directors could get to meet them and get to know them and to begin having some data discussions about their particular counties. So now we're moving into session 2, and I'll turn it over to Stephanie.
Good morning, everyone. Thank you for taking the time to be here to spend a good amount of your morning with us to enhance your knowledge and understanding in order to be leaders who understand and who also can implement and provide oversight into making sure that we honor tribal sovereignty and honor the Indian Child Welfare Act. Again, I'm Stephanie Weldon. I'm the new director for the Office of Tribal Affairs, and we're going to talk some of this will be, for those of you that were with us, a recap, but we'll go a little bit deeper into talking about what tribal sovereignty is. And I'd just like to acknowledge here, we have 2 judges in Humboldt County. We have the Iraq Chief Judge Abby Abinati and Judge Heinrichs, who launched a joint family wellness court for dependents. And so that court is still going on. I'd just like to acknowledge their work here. But as a sovereign nation and as a government, being able to honor and respect tribal sovereignty, these two judges work together to form this court. And then here we have, the tribe, exercising their sovereign right to catch salmon and to be able to feed their community. And then here you have Governor Newsom along with elected Yurok tribal leaders. And so these are just many examples of the sovereign relationship between governments. Next one. So what is sovereignty and why is it so important and why is it confusing? Just as a reminder, all that history we learned, federal history and since point of contact, tribes had inherent sovereignty, meaning that they existed well before anybody necessarily giving them sovereignty. They had their own forms of government. And then further, for today, the US Constitution declares tribes subject to exclusive power and plenary power of Congress. That means Congress has the ultimate decision-making around expanding or limiting authorities of tribal governments and determining which tribes have federal recognition. And so it's really important to understand that and know that, and that there are a ton of federal Indian law policies and court decisions that really hold the recognizing tribal sovereignty, both the moral and legal obligations to tribes since the existence of treaties. And so those historical acts and treaties play out today, and why you will hear tribes have certain services or access, and why the government has a responsibility to tribes, and why we're going to talk about consultation. Go ahead, next slide. So the other thing is to remember is that tribes are considered what are considered domestic dependent nations, meaning that although they're sovereign, they're dependent within a government within a government. And so in some sense, they're quasi-sovereign. And these are all terms that are important to understand or know at least. And that means that they have governance over their own members and their territory, but they're still dependent upon the authority over to exist and be federally recognized by the federal government. Additionally, treaties are to be liberally constructed in favor of Indian parties, and all ambiguities are to be resolved in their favor. These are kind of the highlights of tribal sovereignty and domestic dependent nations in federal acts. And the other thing to know is that states generally, with some exceptions, do not have authority to regulate Indian affairs on tribal lands and over tribal governments and their members on tribal lands, unless Congress expressly delegates the power to states. And we are in a state in which that has occurred, and we are a public law 280 state, and we'll explain a little bit more about that. And please feel free if I'm going too fast or something doesn't make sense, to put something in the chat. And then I'm sure Dana or somebody will flag me if I need to slow down or take a question. Next slide. So a big question that people often ask, why do tribes get all these rights, or why is that fair, basically? So why isn't it considered unconstitutional when the government provides more rights, protections, and services to Indians? You will often hear that, especially today when there's so much divide and misunderstanding around responsibilities. Well, the reason is the rights and protections and services provided to the federal government flow from citizenship. It's not about just an ethnic group. It's the unique political status of being recognized by the government as a member and as a distinct government, as a federally recognized tribe. It's not from ancestry, race, or culture. And that can be very confusing, but the thing to remember is that federally recognized Indians are recognized because of their political status of a government to government, meaning that sovereign nation, and that the federal government recognizes those sovereign nations. Go ahead, next slide. So why does this matter? And I think the key reasons to know is that there's specific authority and responsibility and rights that are guaranteed through the US government. Also, tribes are inherently sovereign and they have retained specific rights within that existence. However, by federal recognition, that unique political status is granted to tribal members or those that are federally recognized. So there's official specifics that are laid out in this government to government relationship. So some good examples to make it make sense really are specifically related to child welfare. Title 4A, for example, where authorized by statute, tribes can enter into agreements or compacts with states. For example, Title 4E and gaming compacts. So because they're a government, they have the ability to enter into these government to government agreements with states in general. And so there's also a requirement for states to consult with tribes and have official consultation. So CDSS has a consultation policy in order to officially, formally consult with federally recognized tribes. Another very specific example of that is that counties more recently, just in the last few months, now have the requirement to consult with tribes in the development of their 2083 MOUs in the ILTs, specifically AB 153. Can folks hear me? I see someone's putting in the chat that they're having challenges hearing. You all can hear me?
Mhm.
Okay.
Oh, you're fine.
So that's a very good example. So because the tribe is a government, that's why tribes have to be consulted and included in these MOUs because they're a formal government. Another specific example is entering into ICWA protocols with the tribe. And so as an agent of the state, of a child welfare agency, the county has the ability to enter into those protocols. Some examples: Sonoma, San Diego, Humboldt and Hoopa just renegotiated and signed their protocols. I'm sure there are other examples, but those are some specifics. So that's because of the unique government to government relationship that a tribe has. And then, of course, an even more specific example is that counties are required to notice tribes, federally recognized tribes of children as a reason to know and reason to believe. And that's specifically within the provisions of ICWA. Next slide. So does the US engage in a government to government relationship with all tribes? And the answer is no, because there are many tribes who are not federally recognized. It seems a little ironic, but at the same time, the federal government sets the standards for what tribes are federally recognized, even though they may have inherently existed since the beginning of time. Again, another form in which tribes did not have, were not included in the development of what federal recognition looks like. And so that's another example of some of the key themes around federal policies that occurred and continue to exist, where a group of people is not included, yet policies are made about them that really have pretty devastating impacts. So there are many tribes in California and throughout this country that have been here from the beginning of time and cannot meet the federal requirements to become federally recognized, or may not have the resources or ability to do that. The other thing to know is that some states have a formal process for state recognition of non-federally recognized tribes. However, California does not have that process. And so there is acknowledgement around the spirit of ICWA for tribes that are not federally recognized, or in the participation of child welfare proceedings. And so that's important to know. It's included in WIC. However, we don't have a state tribal recognition process. So if you are a member or a descendant or from that tribe and you're not federally recognized, there's a lot of things that those members, including ICWA, aren't fully entitled to because of that lack of federal recognition, hunting and gathering rights, all the rights and protections that individual Indians may have as being a member of a federally recognized tribe. So it's important to think about the spirit of ICWA when coming across these cases and how your agency is handling those. Next. So again, why does federal recognition matter? It's important to know that because it establishes a legal relationship between the tribe and the government. And that matters for ICWA and it matters for a lot of other components, like we talked about earlier, access to some federally guaranteed services that federal recognized Indians have. Next slide. So when we talk about tribal sovereignty, it's important to think about jurisdiction. And this stuff is a little bit heavy, but we'll have some other tools and resources for you as well to look over outside of this PowerPoint. But jurisdiction, the primary emphasis is about power. It describes the power of an office, a nation, a court, or even a committee. When applied to a government, the word means that government's power to govern its own people and territory. And jurisdiction is measured in terms of the power that one government may have in relationship to the power of another, just really simple and broad. So keeping that in mind, go ahead. Next slide. When you think about jurisdiction, it's important to know that tribes are not subordinate, again, to states, but can have government to government relationships with a state. So you're dealing with a nation. So again, there are tribal consultation requirements, both federally and state, and then passed down to counties when it comes to child welfare. And then intergovernmental agreements are important, and we talked about those earlier, but some good examples again of intergovernmental agreements that really outline how concurrent jurisdiction is exercised. So some good examples are cross-deputization agreements. So some tribes have tribal police departments, but under their jurisdiction, they only have the ability to police the laws that the tribe has. But a cross-deputization agreement allows for an agreement between the county sheriff's office or whatever law enforcement and the tribe to jointly be able to exercise authority over state and tribal laws. Joint jurisdictional courts is another example where two courts come together and oversee cases. Natural resource co-management, for example, in state parks that are on tribal lands. Oftentimes protocols are developed because that's ancestral homelands to tribes, and gathering rights and protocols. And then another piece to think about, and it's really important, for a lot of tribes to enter into protocols, they do not want to waive their sovereign immunity. And oftentimes you will have your county councils wanting to do so. And we advise not asking the tribe to do that because it's their sovereign right to be able to govern their people. And so when you ask for sovereign immunity waivers, oftentimes that's a barrier for tribes to entering into agreements. Next slide. So when we also think about jurisdiction, we think about who has responsibility for governing. It's important to know, a lot of folks don't know this because it really impacts child welfare. We are in what's called a Public Law 280 state. And again, Public Law 280 was passed during the Indian reorganization and termination eras. And tribes were not included in this discussion, in this concept that was passed. Particularly what it was is that it requires 5 states, including California, and you can see in the red are the mandatory states, to take over from the federal government extensive criminal and some civil jurisdiction over tribal matters. And tribes were not given a say, again, in this legislation. And what does that mean? So what that means is that the Indian Child Welfare Act generally reserves tribes exclusive jurisdiction over child custody proceedings who live on the reservation. So all these other states that are not in color, orange or red, those tribes have say over their children on their homelands. However, in a Public Law 280 state, that's not the case. That's where you hear where the state has the responsibility via the counties. And so what it did was it deprives the tribe of sole authority over their own internal matters, the care of their own children. So that's why child welfare has the responsibility and why we have what's called concurrent jurisdiction, meaning that the ability to exercise both state and tribes having responsibility over Indian children. And if you look in the orange, those states were optional and optional to Public Law 280. And the red are the mandatory states. And so again, another policy that impacted people, a sovereign nation who was not included in this legislation. And we have to be careful to make sure we're not repeating those same kind of things that occurred in our US history. Go ahead. The other thing to know about Public Law 280, here's another good example. County welfare departments have the same obligations to protect Indian children regardless of whether ICWA applies on or the child resides on a rancheria as with any other child. So oftentimes we hear questions or we hear of examples. Sounds like somebody's on mute. Nicole, can you mute? For example, we'll hear of questions of saying, well, the tribe's got it handled, or the tribe has a 4E agreement, or the tribe has services, we're not going to worry about it. Or the tribe, they live this certain way and we're just going to evaluate that out. So it gets complicated. That's why it's important to have not only follow ICWA, but also have protocols and agreements with tribes in your area so you can work out that process of what that looks like. So, a good example, county welfare departments, this is the specific language, have the obligation to respond to all emergency calls. And county welfare departments shall respond to any report of imminent danger to a child immediately in all of the reports within 10 calendar days. Well, you all know the 10-day rule, but that applies on Indian lands. And you might think, well, how's that any different? Well, in those other non-Public Law 280 states, that's not the case. And then an important exception is a non-emergency child welfare case where the child is already a ward of tribal court. In that instance, that tribal court retains exclusive jurisdiction regardless of where the child lives. So in other words, a state court is unable to unilaterally take such a case away from a tribal court. And so a good example is a tribal court might have a case already, and you might get a call, a hotline report of an Indian child. That's why it's important also to have such agreements so you're aware and you're at the screener level or at the investigation level at both areas that those questions are being asked, because if that case is already in tribal court, you cannot petition to bring it into state court. I'm going to pause and see if there's any questions about that. Okay, we'll move to the next one. So thinking about that, the overlay of jurisdiction, we want to share with you a little bit more about tribes. We know for many of you, you might say, well, there's no tribes in my area. Or how do I know what the tribe has to offer? Or how do I work with the tribe? And so our intention here is to give you some basic information about how tribes function, and then we'll launch into further down into the agenda into how you engage with tribes. So go ahead. Many tribes have many different forms of structure and governing, but most tribes have their own form of governing their people. Many of them may look very similar to a county, state, or even federal system, with an overlay of their traditional values and practices, and some look very different. The reason why you will see many similarities is that many of the tribes, if you reflect back on history, in order to become federally recognized, had to fit into a certain template or a mold. And much of that mold resembles our US government system rather than their own traditional forms of government. So if you want to be recognized as a sovereign, you have to look and act like this nation rather than your own ways of doing things. And so you'll see a lot of infrastructure that looks,
Okay, I'll head down. Okay, bye.
that looks very similar. However, a lot of tribes now, their codes and their practices, they're overlaying their traditional ways of government on top of that. So around 60% of tribal governments are based on this model, what was known as the Indian Reorganization Act constitutions that were patterned after the US government. But many of them were kept much of their similar, their traditional ways of being in there. You'll find that their territory, their eligibility for citizenship, their governing body, and their powers are within this constitution. A lot of them have legislative authority to elective tribal council, and many constitutions have titles that resemble either a tribal chairperson, president, governor, or chief. And then many tribes are establishing and have had their own tribal courts, and many judges are either elected or appointed. And the thing to note that's really important that might seem foreign to us is that many of the tribal courts may not be separate. You may not see a separation of powers. An elected governing body may convene in a judicial capacity to rule on issues. An example that's like that is tribal customary adoption, for example. Some tribal councils do the tribal customary adoption order, and they may not have a tribal court, or one of their tribal council members may function as the judge. So every tribe looks different. That's what's important to know. They're different nations. They're all separate, unique nations. Next slide. So again, many tribes have a lot of their own power, to select their own form of government, to make and enforce laws, to define and regulate use of their territory. And then, of course, their power to determine membership, to regulate trade within its borders, to impose and collect taxes. That's kind of somewhat limited, we'll say that much. That ability has been limited with Public Law 280 and some other political challenges. And then power to regulate domestic relations, and then the power to regulate property. Next slide. And then the other thing to know, again, is not one size fits all. So every tribe is different, and every individual, there are different terms. And so at the individual and legal level, these can get really confusing. And so you will hear things as Indian people say, well, I'm Native American, I'm American Indian Alaska Native, or I'm Indian. And it's really important as individuals that you ask what their preference is, like anyone else. What do they prefer to be called? And then the second lane of that is that there are legal implications for each of these terms. That's why you will hear interchangeably different terms being used, and it's important to recognize what that is. So Native American is a broad usage term, and it came around in the 1970s and was an alternative to American Indian. And so it gradually expanded to include all Native people of the United States. However, compared to American Indian, Alaska Native, that is an AFGAR's race definition. And so it's defined as a race, origins in any of the original peoples of North and South America, including Central America, and maintains tribal affiliation or community attachment. So it's both a legal term and an individual community term. And then when you hear the term Indian, It's very specific to political status, the definition, and it's specifically used in the Indian Child Welfare Act. So it's important, and when speaking about ICWA, you use the term Indian. But when it comes to individuals, again, ask. The other thing to recognize about tribes is that tribes have varying different capacities, both operationally and legal capacity. And so tribes have authority, their authority varies with capacity of the tribal engagement and how they're able to fill a role or a position. They have legal rights. We talked about those earlier. They have the capacity, depending on their size, to contract or to be a grantee. They can both be a contractor and a grantee. Stakeholder, often tribes don't like to be called that term because of their sovereign status, so it's important to recognize that. But their ability to participate in things depends on their capacity and ability to do so. The other thing to know is that some tribes are very, very small and have very small budgets, and their economies are small. Some tribes have just been federally recognized, so they are just starting out as a government and have, oftentimes, are building not only their staff, but their operational ability as well as their funding levels. To know that most tribes don't have a taxation base. They are guaranteed specific funding, and it's very little through the Bureau of Indian Affairs. And so they don't have the same capacity as county and state governments do because they're not funded in the same way. Many tribes, especially in California, are grant funded. There are a lot of tribes growing and exercising their ability to enter into governmental agreements to do. Of course, there's gaming, and there are many tribes who are very successful. Gaming is not the only economic venture. There are other economic abilities that tribes have the ability to do, like ecotourism. You'll see businesses, you'll see tribes come together and going in joint business ventures together, but it really has a lot to do with that federal recognition and where they are located and the opportunities and access. And you will also hear the term consortium. Many tribes for healthcare band together and are in a consortium. There are tribal organizations, and they're not necessarily a tribal government, but they're a consortium of tribes together. Next slide. So again, some tribes have many different departments and services depending on their capacity and how long they've been federally recognized or the resources that they have available to them. You'll see some tribes that have a public safety and justice department. You'll see some with the economic department. You'll see some with tribal TANF programs, some with broadband and communications division. Many tribes are without access to efficient technology and broadband. So you probably saw in just the most recent budget that was passed in the act, where tribes are getting a lot more funding from the federal government to have access to communications and technology. There are still many tribes who do not have access and who do not even have electricity on the reservation. So it all depends, but it's important to recognize that not all tribes have the same resources. Next. And then many tribes are in this time frame of revitalization, of healing, of course, because not only do we have the government side, but we also have the cultural piece of things where much of the culture and traditions were not allowed to happen for tribal people and tribes. And so a lot of tribes, you'll see a lot of services and youth programs and family programs that are in the process of revitalizing their culture and engaged in ceremonies and bringing back practices that were once not allowed to occur. And so these are just some examples of Wiyot people. They were able to obtain some of their ancestral homeland, as well as the Eureka City Council gave back, gave back part of their island. And this is one of the ceremonies they had in order to recognize that. So, you know, being able to obtain their ancestral homeland and where their significant ceremonies occurred. And you'll see more and more of that revitalization and advocacy. And why that's important, especially to families that are disconnected or that have been isolated or that are at risk or even currently involved with child welfare, that connection is so incredibly important to know who they are and have that healthy connection to their community and their land. And so it's important to know what tribes you're working with, or your staff to know, and what's available, and how might your county services or all county dollars be able to help support some of those healing and opportunities. And I'm sure our panel will talk maybe about some of that as well, some of your prevention or part of your FFPSA plan, or even your OCAP funding. These are all opportunities to partner with your tribes to engage the families that you're serving. Next slide. So again, just as a summary, because of the federal trust responsibility of sovereign nations, the federal government has a legal obligation to provide specific health care, education, and other responsibilities established not only by treaty, but as this trust relationship. So oftentimes you'll hear folks say things like, oh, tribal people, they don't have to pay taxes and they get free healthcare and free education. That's not quite correct. There are obligations the federal government has, but as we all know in government, things don't always come out the way as the commitment is. For example, Indian healthcare services, Indian people that are eligible do receive healthcare through Indian Health. But the thing to know, especially in California, is that Indian healthcare is funded much, much lower than even Medi-Cal is. And so what kind of healthcare do you think is provided, or it's hard for those Indian health services to be able to provide what the population needs? It's just one example. And taxation, we pay taxes. If you live and work on the reservation, state taxes is a different story, but we pay sales tax. I pay federal tax. You know, that's misinformation. But you know, there are educational services that the tribe, through this legal responsibility, has. Often tribes, depending on their capacity, you'll see Head Start services, Johnson O'Malley education tutoring programs, cultural services. Tribes get a small amount of ICWA money. For the largest tribe in California, they received a little tiny bit of money for their ICWA programs. So just know that even though you may hear tribes are promised these things, it's just pennies compared to what it takes to run these kinds of programs, and much less than what probably counties receive through county realignment. So know that when you hear your tribal partner saying, we don't have the resources, this is what they're referring to often, is not only the funding, of course, staff and infrastructure. Next slide. So I'm gonna take a little bit of a break here and see if there's any questions before we move into the next section. Any brief questions or comments that folks would like to share? I know I'm throwing our team a little wrench here by asking you all if you have questions, because we hadn't planned for that, but I've been talking a lot and I want to see if there's any comments or questions.
I have just one question. I think I already have the answer for it, but I'm just curious and I'm Arturo Perez at the County of Santa Cruz. With regards to Public Law 280, why is it that a state like California is required as opposed to other states that can choose to? So
those other states, that was back when it was passed. And so there's no really option now. It looks like I'm not even looking at you. On my other screen went to sleep. Sorry if it doesn't look like I'm looking at you. But you know, now the only way out of it is for the state to start a process called retrocession. And both, I think that's probably not the most favorable at this time. But when it was passed I'm not really sure it was an opt-in, and some were told they had to. And I don't know, Sylvia, or I don't know if Jennifer's on, if you know, back in the 50s and 60s when this was passed, if there was, the states had the authority or they were just told. Some were optional. I don't know how California ended up in that mix, to be honest with you.
I
Not
don't
sure.
know either.
Yeah. Maybe it was who had the loudest voices in Congress. I don't know. Maybe. Or the last one of the, the last few states to come in. Maybe not. I don't know. Flip of a coin, maybe. But now it's not really an option now. There is a process for California to pull out, but it's a pretty big deal. It's been talked about over the years, both by tribes and the state, but that's not something I think is that folks want to take on, is what I hear, the climate.
Thanks.
Yeah, good question though. I'll have to do more research and find out. Okay, now we're going to move into tribal engagement and tribal consultation. We're a little bit ahead on our agenda. I think I rushed through a few of those. But it's good to be ahead and rather than behind. I'm going to hand this over to Jennifer.
Good morning, everybody. Thank you, Stephanie. We are a little bit ahead, and I know that we had invited our panelists to join at 10, and I think some of them are here. I'm not sure if everyone's here, but I can go ahead and introduce the purpose of the panel, and we can introduce those that are here and get started where we can. So the purpose of our panel is to hear and to learn from our colleagues and our peers representing tribal organizations and counties about how they define engagement, the benefits of partnership, and ways to ensure that this partnership lasts. And we wanted to invite you to connect what you hear from our panelists with the core practice model leadership behaviors, partnership, teaming, engagement, and accountability. I will turn it over to my colleague and my friend, Leah Lujan, to introduce the structure of the panel and to introduce the panelists.
Hi, good morning. So this morning we have a panel. They are paired, a county and tribe pair. And so we have 3 questions for them. So each pair will take 1 question each. So I would like to introduce our panel. We have 3 regions that are represented, and we're so appreciative of them joining today and being part of this, sharing their journey. So from the Southern region, we have Karen Kolb. She's with the Indian Health Council. And so she's partnering with Kim Giardina. She is the Director of Child Welfare Services for San Diego County. For our Central region, we have Stacy Stahl. She is from the Washoe tribe, and she will be partnering with Nicole Williamson. She is the Alpine County Administrative Officer. And then also for the Northern region, we have Chris Piekarski. He is the Indian Child Welfare Act coordinator with the Redwood Valley Little River Band of Pomo Indians. And partnering with him is Gina Connor. She is the Deputy Director from Mendocino County. So thank you all for joining us.
So our first question is directed to our Southern region partners. So this would be Kim and Karen. So the first question, and Kim, I see you. It's hard for me to see everyone. Has Karen joined us? She isn't here. Okay, so we're gonna go a little bit out of order. Do we have Chris Piekarski with us? I saw Gina. Chris,
Jennifer, do we want to take just a couple of minutes to wait for, make sure you have everyone? Do we want to take a little pause, or do you want to just go forward?
I'm open.
I'd say, let me just jump in and say, yeah, let's take a 5-minute stretch break.
Okay.
Let it go till 10 o'clock. And it's a good time for me to remind people, if you put yourself on speaker view.
Hi, everyone. Thank you for giving us a few minutes. Do we have Karen Kolb with us?
Jennifer, I spoke with Karen on the phone, and unfortunately she had a family emergency, so she won't be able to join us today. But she definitely wanted to express her apologies, and knows that the relationship that she has with Kim, that Kim's gonna do a wonderful job. And she's also heard that Bea and Tony were on this call too from San Diego County, and just she really wanted to highlight the great relationship that the tribe does have with San Diego County, but unfortunately she's not able to make it. So sorry about that.
That's all. Thank you, Donald. I appreciate you letting us know and reaching out to her, and I hope that everything will resolve itself. Kim, are you okay to speak on behalf of the partnership?
I will definitely do my best. It won't be the same without Karen, but yes.
Thank you. We've had a number of examples of adaptive leadership in the moment this morning, so you're number 2 for now. So tell us how your partnership began and how you nurture it now or could nurture it further, and why this partnership is important.
Great. Thanks. Good morning, everybody. Thanks for having us. Karen and I were meeting about this last week just to kind of talk about, what we thought about our partnership. The formal relationship between like the county and our tribal partners and really began back in 1990. We established a tribal liaison for the first time and really started building that relationship over time. Our Indian Specialty Unit was formed in 1992, which then helped further sort of solidify really our relationship. So we have all of our cases with families who are tribal affiliated go to our Indian Specialty Unit, and they work very, very closely with our tribal partners. Karen and I were joking, we don't even remember when we met. We've known each other for so long. I was a frontline social worker when I first met Karen. She helped with many of the families that I work with. I did not specifically work in the Indian Specialty Unit, but I worked out in our rural parts of East County. So sometimes we didn't know right away that we were partnering and working with a tribal family. And so when that happened and I went out in the field, called Karen for help to make sure we were doing right by that family. So our relationship has also been going on for a very long time. We've had so many ways that we've nurtured this partnership formally through our tribes being an active part of our county self-assessment and system improvement plan processes. We have we've had some form of fairness and equity, race and equity, different committees throughout the years, and our tribes have always been part of that work. And we continue to just have regular ongoing communication. Our Indian Specialty Unit meets monthly with both Indian Health Council and Southern Indian Health Council. We have joint multidisciplinary team meetings, joint child protection team meetings, so that we can facilitate that regular conversation about the families and the work with our families. From the larger level, we also have our 7th generation work group meetings. Those have been going on for many years. And initially, we're just between San Diego and our tribal partners and have now expanded to include more of our counties. This year, I've been really excited. Our judges have decided to elevate some of the work and have started our San Diego Tribal Justice Collaborative. So our presiding judge, as well as one of our tribal judges, co-lead that group. And I attend, as well as our probation partners and many other partners who help do this work, so that we can start to really talk about some of the pieces specifically related to the justice side. It's not just about sort of what we do as the child welfare agency, but our child welfare system is much broader than that. And so how do we begin to think about some of those issues and work through some of those components? So thinking about law enforcement involvement, our court involvement, all of those different aspects. So those have been happening all year, and really feel like we're getting to some really good work there and figuring out how to make some improvements around data sharing and just, again, building those relationships across our families. So, we thought when we think about how we could continue to nurture it further, We're really excited to be getting started on our planning for part 1 of the Family First Prevention Services Act. And our tribes have already been included with us in thinking through how we're going to develop our tribal pathway as part of that Family First plan. And so we're actually thinking about, how do we help support our tribes in developing some of the capacity to do the services that are available under Family First, what that would look like. Indian Health Council has already completed their readiness assessment for us, and we're super excited to continue. So we think really our work will continue to evolve a lot more around our prevention area and being much more upstream and focusing on the ways that we do that work. So I know Karen would have said things maybe a little more eloquently. She's such a beautiful representative of the work and just speaks so much from her heart. So we will send her lots of wishes for her family emergency. But I'm happy to answer any questions from that, or Jennifer, turn it back over for the next group.
Thanks, Kim. I heard some great examples there of teaming in partnership and co-creation, especially with the example that you gave with the FFPSA. So just really appreciate you being here and lifting that up for everybody. Leah?
All right, so we wanted to invite Chris and also Gina from the Northern region. We had a question for you. We wanted to have you tell us about a challenge you have faced or continue to face in your partnership. And how did you, or do you continue to work through that challenge?
Hi guys, this is Chris from Redwood Valley Rancheria, ICWA. I guess I'll go first, and I just want to thank Layla Daron so much for inviting me to this. I've worked with Layla and her mother, Liz Elgin, and grandma, Lorraine Lewa, for many years, and I have a lot of respect for them, and I was really feel privileged to be here. But yes, so just a little quick thing about me. I've worked for Redwood Valley Rancheria, ICWA. Now it's been 5 years in September, and a little background is I also I actually worked with Gina with Mendocino County Family and Children's Services starting back in 2007. And at one point, when I was a little social worker assistant, Gina was my supervisor in the court emergency response unit. And then eventually I became the first AB 12 extended foster care social worker when Gina became the deputy director. So we've had a really good working relationship. And I think that's really helped me working with county child welfare. I have folks I've worked with there. I have good relationships, and that's really been wonderful in doing our work. We're a rural county of 90,000 people, very large geographically. We have 10 Native American tribes that are federally registered. So we're a big county. We're stretched out, but we're rural. But we're able also to work closely together. And this is very timely that we were invited to this to participate, because since I've been working with Redwood Valley Rancheria, Gina and I and the agency have been trying to update our ICWA protocol, which can be quite a bear of a process. And with the regs being updated in 2016, literally, I would say about a year ago, we finally got this process going, and it's been quite intensive. We were doing quarterly ICWA roundtable meetings, which became monthly, and now we have several sub work groups every month for the past year. And it's amazing. It's just such great progress we're making together. And I think, that being said, we can have these meetings several times a month, but the problems that happen are, the new protocol isn't in effect yet. So we're wondering, okay, the trickle down to the frontline staff. And so I'm ICWA for my tribe. So I'm basically child welfare for my entire tribe. And, we're about 250 members. So we're a small tribe, but that being said, there can be glitches in our daily day-to-day interactions with the county. The county is super responsive to any referrals and any cases, but there are hiccups because folks aren't sitting in these meetings and doing the protocol. They're out there on the front lines dealing with 30 something cases. So that'll be the challenge going forward, is making sure that the staff is educated. But we also have a really interesting project going on right now besides the protocol, and it's we're working with some Title IV refunding with the local Mendocino County Youth Project. And so that funding is actually being, the idea is to educate child welfare social workers on R10, R10 Mendocino County tribes and what their history is regarding to historical trauma, the histories of the tribes. And not a lot of folks, even if they were born, I'm from New York State myself originally, and I've been here 15 years, but there are folks who've grown up in this county who don't know the history of the tribes and what these populations have been through. So what we're doing right now is we are having, the idea going forward is we're having either an elder or a tribal historian from each of the tribes do a little webinar talking about their tribe's history and personal experiences. And ultimately the idea would be to, and we're working towards this, is to have these as recordings, and at some point, hopefully be something that the Mendocino County Family and Children's Services can provide to their staff, their frontline social workers, to, on their time, just to learn a little bit about each of the tribes. And I think that's a wonderful thing. And I know I am very open whenever I work with a social worker who is new. Come on out, come out, meet us, come out to our rancheria. Let me introduce you to our staff. This is a healthy community, because basically I see ICWA and Mendocino County Family and Children's Services. We're collaborators. We're here to work with these families, to keep them intact, to reunify them, and to get the best outcomes. So I don't see them as adversaries at all. I see them as we're collaborators to do the best we can for our families. So that's kind of my little spiel, and I'll let Gina go ahead.
Thanks. Good morning. So Chris gave this summary I had written up. He and I talked about the topic we were going to discuss, but not anything else. So this is all just, we're just going for it. Chris was one of the ones that, like, back in 2017-ish, right after the 2016 new regulations came into effect, was on me about, when are we going to update the protocol? When are we going to update the protocol? And so I finally got staff to do that. But one of the things with our ICWA roundtable that started way back in at least early 2000. So when I started with the county in 2000, it was already going. And we borrowed, our first ICWA protocol was developed in 2003, which we borrowed from Sonoma County. So thank you, Sonoma. And then since then, it has always been updated previously through the roundtable. So we literally would go through it line by line and update. And what I was just thinking about in terms of thinking about challenges and then how we work through them. As Chris mentioned, with this current iteration of trying to update our protocol, going through it line by line in the roundtable was not the best way to do it. And so having the work groups go through them and then bringing it back to the roundtable. But we still are encountering challenges with that, with not everybody is always able to participate in the work groups, and then not always up to speed. And so we're now almost a year in, and we've gone through about 3 sections, and we still haven't nailed down those 3. So we're going to take a different approach. We talked about it this month's roundtable to sort of help move things forward, because as Chris mentioned, I want to get this out to staff because it really is important that staff are following all of the new regulations and understand the purpose of it. Some of the challenges we encounter from the county side in this work is really looking at what tribes would like us to do that are beyond state or federal regulations or laws, and what we can commit to and what we can't. Also ensuring that everybody that's involved in a case understands what's happening and understands why things are happening. Some of the issues that come up involve paternity, like in dependency cases, paternity is something that must be established regardless of whether ICWA applies or not. But that does cause some issues with tribes who are letting us know that a child is a member of or eligible for a tribe without needing paternity established. One of the big things that we're working through with our protocol that it might be that we land on, it's just an area we agree to disagree. With our county, we have many families that the child may be eligible for more than one tribe. And when that happens, most of our local tribes all want to be part of the case. And so we've been working through the WIC 224.1, which gives a process to identify a lead tribe. And many of our local tribes, that doesn't fit with how they want to work with families, and they want to work together as tribes. So how to work through that when it's different than what the statute outlines. And then also some of that is driven by whatever perspective our judge at the time has. We've had different judges and they have different views. So that's a challenge to work through, how to be respectful of both the county's issues and the tribes and how they want to work together, but also planning for what happens when there's disagreements among the tribe, and we haven't addressed that because that has also happened as well. Also getting really good with communication and understanding from the county's perspective of the tribes processes. There are 10 tribes and many of them have very different processes. And so one of the things our work groups are getting really specific on is when the tribes exercise their authority to do a tribal home approval, which we fully support, and that's the process. But some tribes have an emergency tribal home approval process, and then they want the family to go through the county's RFA process. And so there were times where we weren't clear what was happening. We thought the tribe had already approved the home, and then we're behind on getting them through RFA. So we realized early on getting really good communication about that and what's happening. And also another challenge, although fortunately it hasn't happened recently, but we have had, over the past 10 years or so, when another party to the case, and this has come up a few times with child's attorney, when they want a different permanency outcome than the tribe supports. And so how to partner with the tribe and strategize with them and work with them, and not getting sort of lumped in with the child's attorney's perspective. And this comes down to our local tribes. Most all of them support legal guardianship, and that really is their preferred permanent plan. We've only had a few tribal customary adoptions, and they definitely do not support conventional adoptions. So working through that when another party to the case wants something different. And then also just recognizing each tribe is different. They are their own sovereign nation, and how to navigate that when there are similarities, but then there are also differences, different processes for how each tribe wants to engage with the county and updating the protocol. So just really differences, but similarities, and how to work through that. And then, as Chris mentioned, several of us have been with the county for a very long time, and having consistent staffing both on the county side as well as on the tribe side, I think has helped with that partnering relationship, because it definitely takes time to develop those good working relationships and trust. Also making sure that my staff respect tribal requests. So for example, before they go on tribal land, they are contacting the ICWA worker or a designee to get permission to go on tribal land, coordinating with the ICWA representatives for investigations, even monthly contacts, and then ensuring that the ICWA representatives are involved throughout the case. Some things we've worked through the in our ICWA roundtable meetings are, for example, ensuring that ICWA representatives have a lot of advance notice for our child and family team meetings. You know, they have a lot of cases, a lot of different places. And so, you know, giving them more than 24 hours notice is absolutely required if we need their participation, which we do. Also having regular communication about services and programs, both on the county side as well as the tribe side, so that staff know on both sides what's happening, and then if there are issues with services, how to work through those quickly so that the client is able to move forward. And then I think, so for the past, since last year, we moved our ICWA roundtables to Zoom meetings. And I think that has definitely helped expand the participation of the different ICWA representatives. When we were meeting in person prior to that, it was hit or miss. You know, you might get a few ICWA representatives one month and then Chris the next month, and you know, this being the sole person. So I think that has definitely helped and has been a good thing. And then the other things that we have done, mostly when we were meeting in person, but really taking the lead. So the county had been the lead facilitating the ICWA roundtable with a tribal attorney for many years. And then both of those attorneys, one retired and one moved. And then from there, the county picked it up going forward. And then ICWA workers wanted to take the lead on doing that. And so we were happy to help facilitate that going forward. And I think Chris did that for almost a year. They were trying to rotate. And then it just recognizing that that's a lot to do to keep up with, you know, setting an agenda, getting it out, meeting minutes, all of that. So at the tribe's request, we've taken that back on. And then also rotating, when we met in person, we did rotate to the different tribes. And that way it wasn't all just happening at the county offices. So our staff would go to the roundtables at different locations, and the tribal representatives also would go to different locations. So I think all of those are examples of how we work through the challenges. We certainly, we don't have it perfect by any means. It's always a work in progress, but I think just being respectful of each other has helped a long way.
Thank you both. I just had a little quick follow-up question that came to mind as you were talking. It sounds like, you know, there's a lot of time and this commitment that you have to this work is evident. I kind of pose this to both of you. What keeps you coming back time after time to continue meeting together and making a priority? It shows this is a priority. So what keeps you coming back and continuing this work?
Well, I would say, I think just the, like Gina said, you know, back in the day, we would meet monthly or quarterly, monthly, but now it just seems like there's having this, you know, several time a month engagement, and you just get to know each other better. And, you know, again, I'm fortunate. I worked for the agency in the past, so I know folks, but it's for the other tribes who don't. It's just getting to know each other, to listen to one another, to trust each other, and like I said earlier, it's a collaboration. We're both out. Our goals, you know, the ICWA representatives and the county child welfare, our goals is to get these families back together, however we can do it. And, you know, we've been fortunate, you know, I think in a weird way, the pandemic has just been, you know, Zoom, everybody is like zoomed out, but you get better participation. And also during the last few years, you know, a lot of our tribes have been able to kind of step up and get supportive services that may be culturally appropriate supportive services that weren't there before, you know, parenting classes, substance abuse coordinators, you know, you name it. There's all these services are starting to build, and I'm you know, and I'm you know, I'm sure the agency and Gina is glad that, you know, here, you know, let's have our folks come over to us, and you know, they don't have to go to the family center or go to these other, you know, county sponsored programs. And, you know, I feel also, you know, part of my job is, we're not adversaries, and, you know, I'm working with social workers that have 30 something cases, and I have a fraction of that. And I'm like, you know, I could take that burden off of you. Come on over here, since let's have our parents do visits here at our rancheria. And, you know, it's just we've been able to develop a lot more trust. So that's a key for me.
Yeah, those are beautiful examples of teaming. Gina, what about you?
I think for me, the same thing, recognizing that partnership is crucial and that we need that partnership. We can't do this work alone. We need it. And, you know, a couple of years ago, we were in a place where our roundtables were very adversarial. My staff did not want to come. It was always like, oh goodness, you know, what are they going to bring up now and get mad at us about? And really working through that and recognizing when we've messed up, we own it and we figure out how to repair it and also don't do it again. So I think just having that commitment to work through it, because we both need each other to protect our kids in our county.
So well said. Thank you both so much. Jennifer?
Thank you. So unfortunately, we've learned that Stacy Stahl, who was to join us from the Washoe tribe, is not able to be with us today. So Nicole, we just appreciate that you're here and willing to speak on behalf of your partnership between Alpine County and the Washoe tribe. So our question for you is, what have you put into place to ensure that this partnership between the tribe and the county continues to effectively serve Native children and families beyond your tenures as leaders?
Okay, good morning. I'm Nicole Williamson. I am the County Administrative Officer, but I'm also the Human Health and Human Services Director. So I wear two hats. So I am still the Social Services Director. And before I can talk about how we ensure the future, I need to talk a little bit about how we got where we are, because the situation with Alpine County and the Washoe tribe is unique in California. In fact, as far as I know, unless something's changed, it's the only partnership like this in the state of California. The Washoe tribe obtained exclusive jurisdiction of all children, all Washoe children and all children that reside on their land in 1996. And during that time, for many, many years, the relationship between the Washoe tribe and Alpine County was not very good. In fact, it was terrible. And so when I talk about it, you know, I say that if the Washoe tribe and Alpine County can have the relationship that we have today, any other county and tribe can do it too, because we were not in a good place for many, many years. So in 2010, I started working for the county, and there'd been some attempts to try and get a memorandum of understanding between Alpine County and the Washoe tribe so that the county could provide child welfare services to the tribe. And it took a couple of years. We went through a process we hired outside counsel to help us with this memorandum of understanding. We hired Maureen Geary, who, if you know her, I highly recommend her, because she was a neutral party. All she did was negotiate the MOU and draft it for us. And it took us several months, but we got through it, and we signed the MOU in 2014. So since then, we've had the partnership where we provide the majority of child welfare services to the Washoe tribe, Hungalalti community that's in Alpine County. The Washoe tribe has 5 communities. 4 of them in their headquarters are in Nevada, but they have one community in Alpine County. It's the only one in California, and it's called Hungalalti, which means the Southern Band of the Washoe tribe. And so, you know, I will tell you that CDSS staff, nobody on this call, told us they didn't think we could do it. They did not think we'd come to an agreement in our MOU, but we did. And one of the ways that we ensured that it would go past the personalities that negotiated it and signed it is it's a perpetual MOU. It does not have an end date. Either the Washoe tribe or Alpine County has to terminate it. So it just goes on forever. It's one of those things that we don't want to bring up and talk about because, you know, it's done. We have a partnership and a relationship and we want to keep it that way. When we look at other work that we do together, such as we did a CSEC protocol with the Washoe tribe, and I believe we were the first one to do county to do a protocol with the tribe. We signed off on it as CDSS required, but it's an amendment to our MOU. It's not an addendum. It's an extension of it. We did not go renegotiate the MOU to address our CSEC protocol. So anything we do, sort of new mandates as they come down from the state that we involve the tribe in, we just consider these sort of addendums to the MOU instead of going back and changing the MOU. So that's one way we've done that. I think the other way, and I'll say this with my hat as the county administrative officer, is that our relationship with the Washoe tribe is our most important government to government relationship that we have. It's more important to our Board of Supervisors than our relationship with the state of California. And sometimes the tribe and Alpine County partner together to bring issues that impact our community to the state together. For example, we were just working with the Washoe tribe on some historical land that they used to spend the summer in Hope Valley, if you've ever been to Alpine County. And the Fish and Wildlife Commission, in their infinite wisdom, was going to start charging people to use the property, including Washoe people. It was their historical area. So I worked with the tribal chairman, and he, along with Board of Supervisors, and I went to the state, and now Washoe people are allowed to use that without having to buy the lands pass. So it's just an example of, you know, we sort of understand the state government. And so when they need help, we partner with them and help them with issues. And we also work with them during emergencies. They're our first automatic partner when we're looking for assistance, like during the fire. You may have heard of the Tamarack fire this summer. That was in Alpine County, and it burned. At one point, every single one of our county facilities was threatened at one time. And so we had to move our emergency operations center 5 times. And place number 2 was out to the Washoe tribe gym. And so when, you know, we're looking for a partner to help us, they're the first entity that we look to. And if you told me before this fire that the Washoe tribe would save us with internet, I wouldn't have believed you. But during the fire, the fiber was destroyed for 6 miles. And we were, because they're on 395 going through Nevada, they have a high-speed broadband highway. We were able to borrow some of their bandwidth, bounce it off of one of our repeaters, and bring it down into our town immediately, as soon as we asked them. So we just have this partnership where we help each other out. I mean, they have a repeater on our tower we don't charge them for. We recently gave them 5 acres that belong to the county that had their historical cemetery on it. And they're just our partner in everything. And it's really just our it's become our culture that in our county that, you know, this is just our culture, not just in social services, everywhere it's our culture. And that's how I think we've made sure that this partnership will continue. I would like to give you a few little facts about Alpine County. We have the highest Native American population in the state. We're 25%. And we don't have an official number, but we believe at least half our child population is Native, whether they're members of the Washoe tribe or the Paiute tribe or another tribe, but at least half of our child population is Native American. And yeah, I just wanted to pass that along, that we have a large Native American population for the smallest county, but percentage-wise, we have the largest. In the way our Board of Supervisor districts are drawn up, the Washoe tribe always has a representative on our Board of Supervisors. So that really helps in keeping that in the forefront. And I just want to make a plug for a lot of the work that we've been doing. We've partnered with Tribal Law and Policy Institute If you don't know them, I'd be happy to refer you to them, but they are a Native American run organization and they provide a lot of technical assistance for a lot of federal grants. I actually started working with them because Suzanne Garcia, who works for them, used to be the Washoe Tribes Council, and it was her that I negotiated the MOU with. And I heard somebody say they'd become friends with their person too. And she and I have become very good friends. In fact, such good friends that during the Tamarack fire, I evacuated to her house. So, I mean, we've made a friendship out of this work. She helped us with our CSEC protocol. We're going to do some trauma-informed training with the tribe. She's also helping us organize a healing circle for the Washoe tribe related to the loss of their archaeological, cultural, and historical sites in Alpine County. And that's my plug to counties. If you don't know how to reach out to your tribe, you don't know what to do, I highly recommend reaching out to Tribal Law and Policy Institute to help you and work with you, because they'll be able to figure out how to approach the tribe that's in your community in the correct way. And I think they bring some credibility with them also. So that's what I have to say.
Nicole, thank you. In just a few short minutes, I've completely lost track of how many extraordinary examples you shared of true integrated partnership consultation. It's everything that you do. It's so seamless together and it's beautiful. So thank you. And thank you to all of our panelists for being with us and for sharing your journeys and sharing your stories with us. It's been truly inspirational. And I do hope that we'll all take some things away from this panel. I know I certainly will.
Okay, I think that's me. Jennifer, I want to come alongside you and just thank your panel again. Leah and Jennifer, thank you so much for bringing forward today such incredible leaders with such intention to partner. Nicole, Chris, Gina, Kim, just thank you so much. And we just admire the intention and the sort of the dogged determination of partnership. Nothing. Not fires, not floods, not anything is getting in the way of your partnership. And I just want to thank you so much for those examples. And then just as an aside, Stephanie Weldon, thank you so much this morning. We've learned so much so far about sovereignty and the history and the reason why we really want to ground the rest of our conversation today in this deep respect for sovereignty. But Stephanie, as the director of California's Office of Tribal Affairs, we thank you so much for taking your time to be here and sharing your wisdom and your leadership with the rest of us. And so I just want to say thank you to all of you who have worked so hard to bring the material together for us today, and then give you a little chance to kind of interact with what you've heard so far in terms of ideas that were sparked, inspiration that you had. And I'm just wondering if we could just sort of reflect just a bit on what we heard. I think, a lot of the examples that we heard around partnership were really featured this intentional relationship building on every level, from the friendship that you heard kind of Kim talk about. I don't remember when Karen and I first became friends, but, our bringing our systems together and our organizations together definitely sits at the structural and the systemic level, but it started with this friendship. And you heard the same thing from Chris, his kindness of helping Gina with her frontline staff. Chris walking through the turnover on the front lines, and folks who don't know the ICWA protocol, it's not yet been, it's in a process of adaption, but Chris's kindness on that friendship level at the front lines. And then, we just heard a whole lot from Nicole. Thank you so much, you guys, for sharing. But just in the kind of interest of thinking about, like, everybody on this call today is a leader, and you are stewarding organizational and systemic and structural oversight, so that at every level in your organization, there are relationships, ongoing and sustained relationships on behalf of Native children and families. And so, Stuart, if you could advance the slide, we're going to offer you a chance to kind of interact a little bit with the poll, and then we'll debrief it together, but here are the questions. So this is a chance for you to kind of answer some of the same questions that our panelists answered. What are ways that could help your child welfare program sustain its commitment to tribal engagement, partnership, and respect for tribal sovereignty? So what are some ways that you might take what you've heard today and learned today, and some of the things you may already be doing, just like Kim and Gina and others described, you may already be doing some of these things, and some of these things you might have been excited about hearing. So like the first one, and I'm going to go through these because when we launched the poll, there was a limit on the words, and so we couldn't put these fully packed choices for you. So there's just a few words in each choice. So I wanted to go through real quick. The first one, my gosh, we heard Chris and Gina talk a lot about this engaging in meaningful and consistent communication. Their monthly meetings or quarterly meetings shifted to monthly because they needed that time together to develop their ICWA protocol and develop their MOU. But this consistent communication where, understanding for historic trauma and all kinds of things can be discussed, but it's through that relationship, kind of in that meaningful, maybe monthly brown bags with your tribes, where it's not an issue, but it's like no matter what, first Monday of every month, I'm getting together with my local tribe, and we're going to say, we're going to ask each other, how's it going? What are we learning? What are we seeing? But it's this ongoing systemic commitment to meet that leaders, and that would sit at the child welfare director level, child welfare director and their staff with tribes. The second one, formal contracts with tribes to engage them in consultation services. You heard a lot from Kim. My gosh, there are agreements, and there are structures in place that respect the time of the tribes. So we're not just saying, hey, we've got to have tribes in our meeting, but you're actually going that next level to set up contracts so that folks who come from tribes are reimbursed for their time. And their guidance is really baked into key implementation decisions, which is the third one, that tribal principles and values guide pace and process for implementation. You heard Kim talk about the 2083 process and FFPSA, but we're contracting with tribes so that tribes have a guiding role, and it's truly this partnership. The fourth one, you heard Nicole talk a little bit about this. The Board of Supervisors, going to the Board of Supervisors with a statement of intention that the county social service organization is going to respect the sovereignty of the tribes, and this is what it's going to look like. But some kind of public acknowledgement where you name your tribes and they are with you in this Board of Supervisors moment. And I love what Nicole said, that the relationship with the Washoe tribe is the most important relationship that the Board of Supervisors has. What a stunning example. Number 5, you heard Kim talk a little bit about this with the juvenile court judges and relationship building, so that you're meeting regularly and your tribes are meeting regularly with juvenile court judges, so that there's expanded understanding and appreciation of sovereignty and application of ICWA. You heard from the southern region, this is really taken hold in terms of, like, it started maybe in child welfare, but now it's inclusive of all other systems and even beyond San Diego County, but the 7th generation thing. So that's another shining example, but you can start here with just a monthly brown bag to begin to think about tribal justice. Number 6, partner with your OTA field liaison as you engage your local tribes. And we will hear after the break, we're going to hear from our regional liaisons from each region from the Office of Tribal Affairs. And most of you have already met your own liaison, but it's a great idea to partner with them, especially just a quick call, ask for advice as you're paving your local relationship. Number 7, set up regular case reviews. I love what Gina said. So I think I wrote down, Gina said, sometimes we don't know maybe what is happening and why it's happening. And she talked about that, the example of when a child could affiliate or associate with multiple tribes, or placement preference could wash across more than one tribe. And so these regular case reviews might be opportunities for tribes and county folks to sit down and kind of walk through a case or several cases at a time, but this commitment to really unpack and share an understanding the application of ICWA is another example. 8, invite your local tribes to engage with your workforce for cross-learning and relationship building to happen at the division, at the social worker level, at the supervisor level, but where those relationships sort of unfold to, gosh, what data do we want to look at? Do we want to look at placement? Do we want to look at how we're engaging tribes? We want to look at safe measures data, but what kind of data do we want to look at so that we can, with intention, create maybe a goal or an outcome or something to be regularly reviewed by tribes and county staff. A 9th example is to create an ICWA unit of responsible folks that would be dedicated to develop those relationships on the front lines with tribes. So, this is just a poll, and it's just kind of a fun way of us interacting with you a little bit on some of the things that you've heard this morning. What grabs you? We're going to roll into a poll, and in the spirit of true partnership, imagine that your local tribes are here with you right now. If you a position question, what would your tribes think about one of your local tribes, one or more? What would they want you to dedicate some commitment to, so that this partnership would not just be for right now, but it would be sustained beyond your tenure? So I'm going to launch this poll real quick, and I'm going to give you about 5 minutes or so to think through any of these ideas. And in about 5 minutes, I'm just going to kind of gently call you back and release you to break. You'll have a 10-minute break right after, and then we will debrief. All right, so let's launch the poll. Okay, you've got about 2 more minutes on the poll, and then I'll let you know. We'll take a 10-minute break after. We are at about a 50% completion rate, so I'm looking for a little bit more. Okay, thank you so much, guys. Thanks so much for interacting with us a little bit with this poll, and we'll unpack it in about 10 minutes after break. So I think I am the one that's going to send everybody off. It looks like it's about 10:51. So if you want to come back at about, as you come back from break, take a look at the screen. There are our poll results. Wow, so our highest, our highest score by a hair is embed tribal principles and values into the design and implementation of key practice models and practices. Okay, so that's our highest one. And then our second highest one, it looks like co-create and engage in meaningful and consistent communication between tribal leadership and child welfare leadership. So meaningful and consistent and regular, no matter what. Great, and then our third, we've got our third one is partner with your local OTA field liaison as you engage your local tribes or anytime there is need for support in relationship development. Those are our top three, but they're all really close. Wow, okay, so let's talk just a little bit. I wonder if I could partner just to kind of debrief a little bit for those of you who said, for those of you who responded with one thing you'd like to do is to embed tribal principles and values in your implementation design efforts. Yeah, would somebody be willing to come off mute and just give me an example? And I also want to invite the OTA liaisons or Stephanie, if you want to also engage in this conversation a little bit. What is an example of a tribal principle or value that we would want to be centered in as we think about implementation and design? What's an example of a tribal value or principle that might center us? Stephanie or Layla or Donald, what's an example of a tribal principle? On.
Okay, I'll say something. I try to wait, but then it's like, oh, okay, I guess I'll say it. I think it's the realization that children are the most precious resource of a tribe. And because of that, it's a spiritual practice when we talk about kids. And so, and we know that all of our education and the future perseverance and the future preservation of our tribe is all within our kids. So we take this very seriously. So the work that we're all do together, it's really a spiritual kind of work as well. It's a healing kind of work. And it's not just a job. It's not just our good benefits that we're receiving. It's definitely something more than that. So it's that's what I'm thinking of. I don't know if anyone else wants to share.
Thank you so much. Thanks for just that little improv TA for all of us to really, as we think across our child welfare organizations about all of the things that we're struggling with in terms of system change and practice change and mandates, and particularly around placing kids with a lot of needs and working cross system, but for us to stay centered on how sacred the sacred work, the spiritual nature of the work, so that we don't rush through in terms of creating structures for change, but we stay centered on the spiritual work at hand. So thank you, Donald. That's a great example. We should probably continue that conversation in another venue, because this would be a great conversation. Oh, Judy has something in chat. Yes. Yep. The decolonizing the way that we think about change management as well, from the sequential nature of our planning to the Gantt charts to the time frames and the deliverables. And we can get so just the cultural characteristics of the white supremacist organization, that those could really shine if we're not careful. Thank you, Judy, for lifting that up.
If I could add to that and give a really good example is I've heard on the flip side, practitioners say things like, well, the tribe doesn't know our laws or SDM. So rather than leaning in to understand the tribe's perspective around their Indian community standards and valuing and trusting that the tribe knows about their children, even if it's a perspective that seems foreign to you or not in alignment with your own values and practice, as well as the agency understanding of values and practice, and trying to lean in to better understand what the tribe's values are. So another example of incorporating that, I've heard of a relationship where the tribe has asked the county, even if you come on our reservation for non-Indian children, please let us know you're around, out of respect of stepping into our homelands. We know you can't tell us confidential information about other children, but let us know that you're around. Stop by and say hi, and just acknowledge that you're stepping foot on our ancestral homeland.
Thank you so much, Stephanie and Donald and Judy, for the reminder of the sacred nature of this work and the spiritual components. The honoring of children in their communities is something that really, yeah, we needed to hear that today. Thank you for that. And it sounds like everybody sort of responded with, gosh, that's what we want to do better with. That was our top poll response. So we thank you for future continuing to guide us in this work. As a lot of us do a lot of system change work, we hope that we will defer to you guys. The second response was this monthly, or this, well, not monthly necessarily, but this co-creating, you know, what's going to work for you. I think Gina talked a little bit about Zoom, and that it might have been Gina, it might not have been Mendocino County, but on the panel, there was a suggestion that, gosh, when we went to Zoom, I think Chris said that, things got better. And we got a little bit more, our ongoing relationship and meeting time got a little bit easier when we went to Zoom. So that was the second highest response, was to co-create. So it'd be the child welfare organizations and the tribes figuring out, how are we going to do this meaningful, consistent relationship time? How are we going to do this? And in the context of those regular meetings, and I know things come up all the time, but that commitment at that top level, that senior leadership level commitment, what that models regularly, if it's monthly or weekly or quarterly, but what it models for the top leader to say that that meeting is the most important meeting for me. All kinds of good things can happen. So that was your second response. And your third one was to partner with the OTA liaisons. And I'm going to actually turn it right over to the OTA liaisons right now. So I have the honor of passing the baton to Donald Rodriguez.
Hey, hi, everyone. I'm Donald Rodriguez, your Southern California ICWA Field Liaison with the Office of Tribal Affairs. That was an amazing panel. So really, the stuff that I was going to talk about was really beautifully described by Kim, Gina, and Nicole from the counties, that the relationships takes work, and the realization that the agencies that we work for, I with the state, you guys with the county, that there's a history there, and not a very good history either, that we need to confront if we're going to go forward in building this relationship. When you think about that, and we've heard about the history, and you're employed by that agency in which inflicted a lot of this trauma upon sovereign nations, and there's still that hurt there, there's still that mistrust there, and you, as the face of the state or as the face of the county, have to acknowledge that, even though you didn't do it, the agency that you represent did. And so I have found in my work, and what I've been hearing from some of the tribes, is that it's good to have that acknowledged so that it cannot happen again. I think Gina was saying that too, from Mendocino County, like, hey, if you guys mess up, acknowledge that, and let's figure out a way that this is not going to happen again, and figure out a way that we can work together and partner on that. And big shout out to Chris. He was here on his vacation, so thank you very much. And that's another good example of sometimes we're having to work through things. lot of these tribal social service directors wear many hats and they are pulled in many different directions, and they can't always attend to some meetings, and sometimes just got to adjust and do that with as much respect as we can. So if you are from that county who is unable to partner, please reach out to Gina, reach out to Nicole and Kim, and figure out some of those other ways that they utilize in order to create this great system that they have right now. What I really want to talk about here is, again, just be transparent. If you can't do something, share it. There's no reason to keep all the cards up to your chest. Show them what's going on. Obviously, you can't talk about other issues of reporting party or things like that, but the sharing of information will definitely go a long way. Another point about this is, please remember that those who are in the sovereign nation government, they're elected. So as you would address Secretary Holland or Assembly Member Ramos, also it's a chairwoman Pinto or Chairman Smith or chairperson, how they want to present themselves. Please also address them that way as well. And then another point that I know Karen wanted me to make sure I said was, make sure that the person you're consulting with is designated by the tribal government to speak on behalf of the tribe. That can be really difficult, especially when you're working with consortiums. So make sure that you dig a little bit deeper, that if that person who is speaking for the tribe, that you also connect with the tribe to make sure that that is who they designated. One way to collaborate is to agree on a happy medium, on a venue that maximizes participation and minimizes that travel expense for all parties. Granted, we're now on Zoom, so we can all be on this kind of Brady Bunch format here. But when we actually go back into person and meet with each other, try to figure out a way that is a shared space. So you're not always only meeting in your county office. You're out there going out and meeting with your tribal partners from where they want to be as well. Develop an agenda with the tribe in advance. And this land acknowledgement, it's good to know where you're coming from. But then I kind of want you to take it a step further. How do you acknowledge that land of the personal house that you're in right now? When you think about that, like, okay, the land, this house that I own and this land that I own, is this mine? I'm going on a tangent here, but you think about that a little bit further, realize that it's all tribal land. And when you acknowledge that, it definitely kind of level sets. You get that understanding that you know your history a little bit. On the next slide, we're going to talk about what practices for meeting with tribes. Again, it was greatly said by Gina, Nicole, and Kim about having that open and honest conversation. Gina was saying that there are a lot of times during those roundtables, there are a lot of disagreements, and sometimes that's going to happen. But it doesn't necessarily mean that it's a bad thing. Just try to work those out. And like Nicole was saying, they partnered with another entity that were those happy mediums that could really balance that conversation. That's what we're also hoping for these ICWA liaisons as well, to develop roundtables so we can discuss some of these issues that are coming up. So please utilize the liaisons too. And make sure not to cut leaders off. Sometimes our elders can speak. They got a lot to say. So let them speak, please. And sometimes there's pauses, kind of like what I'm doing now. I'm not buffering, but give them that time. Because it's really difficult to talk about this. This is not easy. We're having to talk about historical trauma, sovereignty, current issues that are going on, all wrapped in one when we're talking about an individual case. So it can be very difficult and frustrating. So please allow enough time in order for them to express themselves. Definitely use plain language, try not to utilize acronyms. I know given the county speak that we have and the state speak, we often talk in acronyms or SB7. We understand that, but sometimes tribal folks may not, or maybe they do. Probably sometimes better, much better than we do. But try to use as less acronym speak, basically, and to show that you are listening and being an active listener. We have seen practices where people are taking notes live as they're talking. That does depend, because oftentimes, like we're talking about with the written word, it's hard to stay engaged, right? And as we're sitting there taking notes, that can be misconstrued sometimes as well. As, are you really paying attention to what I have to say, or are you just trying to make this a document that I'm going to have to you're going to hold me to, or something like that? But ask for permission to write notes is what I should ask, or what I should say. I think that's kind of what I want to talk about, and I think Fawn will talk further about building our relationships and on trust. Next.
Thank you, Donald. So strong relationships are built on trust and honesty, and as representatives of a professional government agency, always show up to your meetings prepared and ready to really listen to our tribal partners. I know it seems so often we show up when we need to, but really, just as we know, for like our families with ICWA cases, the sooner that you have tribal engagement, the better the outcomes will be. Don't wait till there's a problem, establish that relationship before, because really, if you can over communicate, it's better than under communicating with our partners, and just make sure that whatever is being shared and we're asking for input, that we're really listening and applying, but then be sure to communicate back. I know so often what we hear from tribes is, you guys will come and ask for input, but then we never know the outcome. And I'm glad Donald talked a little bit about, really taking that time to know the history, not only of the relationship of your agency and the tribes that you are working to build that relationship with, but also just know that, as a state, we do have that history of saying things that don't really mean what they say. So just be very clear. And what I mean by that, like when the state of California became a state in 1850, one of the first things we did as a free non-slavery state was establish I know as a different term, but it was actually the Act for the Government and Protection of Indians of 1850, which we know was the Indentured Servitude Act of Native Americans. So just be very clear in what we are trying to achieve, because there is that mistrust. And so again, if we can over communicate, the better, but make sure that, I don't want to say we're doing a smash and grab with input, but make sure that we're really closing that loop up and letting them know the outcome of what we were asking for engagement. Next slide.
Thank you, Fawn. And just to kind of highlight some of the trust, even as Fawn was sharing, making sure we're not checking the box or just needing to get input and not really taking that in. Oftentimes, I think because of, our maybe bias and privilege, or as a system, with the way systems operate, and systems are made up of humans, of all of us, we get accustomed to checking boxes rather than understanding to the intention or trying to listen to better understand and serve differently. I know with a lot of regulations and a lot of policies, and with COVID and folks being short-staffed, it's easy to fall into that routine because we're trying to get our work done and survive. But we have to remember, this is human interaction, and this is ICWA. We're talking about communities that have experienced genocide and are still recovering from those impacts. And that trust also means following through on action items, holding your staff and your team accountable, and yourself. So if you make a commitment, that you come back with that, as Fawn said, and you share what you did with it. and trying to be proactive. That's another part. Sometimes we hear from tribes that, yeah, we have these meetings, but we're tired of meeting. We don't really see any change. And so holding yourself to that to better understand rather than just to meet, you know, what's the action item out of it and what's coming out of that. And how are you as leadership being proactive in looking at the act and strategizing with your team rather than just waiting for the tribe to bring problems to you or something that isn't working. How do you know if your staff at the hotline are inquiring from the hotline and throughout? And how do you know that? What methods are you employing to proactively show up and be prepared? What strategies are you utilizing? So those are all ways of being prepared and following through and being proactive, keeping that in mind. So those strategies shared previously are what we call collaboration or tribal engagement. And OTA, we call that tribal engagement. And that's all incredibly important. And you'll often hear folks use the word consult. I consulted with the tribe. That's much different than the official, what we call big TC, tribal consultation. Tribal consultation is another form of engagement, but it's an actual official act, and it's required by California and CDSS both have a consultation policy. CDSS's policy was finalized in 2017. So if you haven't heard of this and don't know about it, now you do. And we can share that with you. And that's what we do in OTAs, provide that education and awareness. Tribes were part of that process, and it's been revised, and we'll be going through another revision here in the next few months. Also, California Health and Human Services Agency has a tribal consultation policy as well. And they both fall in line with California's Executive Order B10-11. And then counties will also be tasked with developing consultation strategies and policies specifically to meet the requirements of AB. Here I am with my ABs. I sound like a bureaucrat, but the Systems of Care 2083 and the inclusion of tribes with that. So an OTA will be helping provide some education on what that is. So just know, tribal engagement is incredibly important. Next slide, please. And then tribal consultation is an official act specifically with tribal governments. And so what we recommend is that you work with tribes through engagement to develop something together. And then when you go to formally adopt, you officially hold tribal consultation. And it's an official act as a government to government, as we talked about, where you recognize the tribal leaders and they're a part of the meeting. Oftentimes tribal leaders will have their designees or their representatives do a lot of the talking, but it's to honor that commitment and hear from the leadership. Oftentimes, like we say, we ask that folks start with engagement first and then get to some formal consultation. And sometimes it happens the other way, where it's an official consultation first, and then through consultation, you make some agreements to do a work group or a roundtable or a drafting of a protocol. They might assign staff and then ask you to come back for the adoption of it. So it's important to be really clear with your language. Sometimes folks will use the word consult when they don't necessarily need official tribal consultation. So again, when you're doing consultation, include the tribe in the development of that consultation for it to go successful. Venue, brainstorm agenda together before you hold official consultation, making sure that you have options and done the research and have something prepared for consultation to present, and make sure you give timely notice of the meeting date and have materials. And then the other thing we like to recommend and make people aware of is meetings, but even more so consultation. Tribes will often, I think this speaks to a lot what Donald was sharing, tribes will often have an opening or have some kind of spiritual person or a cultural person share, whether it be a song or a prayer or some kind of acknowledgement. And that folks need to be aware of that, and that just display respect for the tribe's customs and beliefs as a tradition. Even though it's a prayer, it's not, folks aren't necessarily trying to get you to convert and pray their way. It's just recognition. So those are all important considerations when you think about consultation, but no, it's an official policy, and that for policy related or agreements, that's when consultation is necessary. OTA can definitely help you if you have questions or are not sure if something should be consultation or not. Next slide. So this is just an example of how consultation could look. When you present an item and you're consulting with the tribe for official consultation, you always ask a question about what you're presenting so you can get an official response. It's good to present, but you have to have a very specific question that you're asking for their feedback on. And this is just a kind of an example of what that could look like. So if you're proposing, we'll say, some kind of new process or an ICWA unit, for example, it would be a good idea to do formal tribal consultation. And a question would be, is the proposed structure and process feasible? Does that work for the tribes? What are specific areas or of the process that you'd like to adjust? And then are there additional ways to achieve this purpose beyond, this is specific to a legislative committee. As you can tell, this was for CDSS, but you would frame your question similar to that. Are there additional ways to achieve the goal that we're trying to achieve together of the ICWA unit, or something to that effect? But you'd want to ask very specific targeted questions because you are dealing with leaders of a nation, and they will likely respond or have their staff respond, but they would be present. Next slide. So those are just some key aspects of consultation, and just know there's a difference between consult and tribal consultation. I'm going to share, we keep referencing Office of Tribal Affairs, and many of you probably already know this, but Office of Tribal Affairs really is set forth to help promote the government to government relationship between the state, tribes, and counties, and Native American organizations to help develop that relationship. Although there's not official consultation there, but it's really to promote those relationships. And what we do is we cultivate participation and amongst all partners and stakeholders related to Indian children and families. And so our values are to respect tribal sovereignty, of course, integrity, transparency, and we try to remain solution focused. When there's a challenge or a barrier, what we do is we try to come up with solutions or help the state or counties come up with solutions. And oftentimes, because of a lack of understanding of tribal affairs or tribal worldview, we often hear a lot of barriers, or because of state government or county government, we hear, well, we can't do that. Well, we really try to encourage, whether it be through technical assistance or some of the work that we're doing directly, is what might be another way to get to the same goal, is really that solution focused kind of inquiry. We do, the folks that we serve though are the counties, tribes, and state departments as well. And so we use the same many similar social work practices and techniques, but with all of you. And so that's what we try to do, is try to build that relationship together. And we provide quite a bit of technical assistance, both internally to CDSS, as well as externally to both tribes and counties via our field liaisons. Next slide, please. And OTA, just know OTA is fairly new, and we launched in 2017. And so this is, I think, our first full year in which we have all of our field liaisons, as well as our small internal team. And so there are about 8 of us, and we provide quite a bit of technical assistance throughout the state and internally. And just to kind of get a snapshot of what we do, we facilitate what's known as the Statewide Tribal Advisory Committee, which is made up as organized representatives of tribes, and there's a county rep that participates. And it's all, of course, the last couple of years virtual, but we have at least 3 Tribal Advisory Committee meetings annually, and where we interact with tribal elected and represented officials, as well as tribal reps, to talk about many of the statewide policies and implementation and issues that are important to tribes. There's been a lot of focus primarily on child welfare and CFSD, but we also bring in issues related to that are support our safety net services, social service related. So CalWorks, Tribal TANF, CalFresh, Medi-Cal, behavioral health, those are often included in our discussions as well. We participate in many of the internal and external work groups, providing advisement, not only on ICWA, but tribal engagement. These are just a few of the examples. The statewide tribal ICWA AFGARS work group, the RFA Indian Community Standards, which is 686. The placement work groups were supporting the revision of the integrated core practice model. Those are just a few of those. And then tribal consultation, of course, we're responsible for coordinating tribal consultation. We host an annual tribal consultation summit with tribes. And then we also facilitate one-on-one consultation with some tribes as they request it and as CDSS puts forward consultation. Also, we provide that technical assistance advising and program and policy shops, both to many branches and bureaus in CDSS, but also to counties. And then right now we are primarily responsible, so many of you may not know this, the CDSS is developing a statewide ICWA plan to improve ICWA compliance and implementation, as well as improve outcomes for Indian children and families. It's in its first year of development, but particularly we are leading in the facilitation and development of that plan to address key areas of ICWA. Soon, county leadership will be brought in as into the developmental phase. So we make sure that we are developing a shared plan together, and we're assisting CDS, or we are CDSS, but we are assisting CFSD in the development of that plan. So it's kind of a snapshot of who we are and what we do, but more so importantly is to talk about our external work and what tools we have available from OTA and our great team that's out in the field, and they can talk a little bit about what they do and how they might be able to support you in your work.
And these are the ICWA field liaisons. I cover the northern region of the state. Layla Daron covers the central region, and Donald covers the southern. And we're really here as a resource and support to our tribal, county, and state partners. And our goal is to improve ICWA practices throughout the 58 counties. Next slide, please. And so this is really where we focus our energy on, and the goal is to strengthen relationships with our tribes, counties, and state. And a way that we do this is by providing technical assistance, collecting and reporting data, and providing training, because really that data is an important piece to informing us where we need to focus our training efforts, and then listening to our tribal and county partners where we can assist with providing that technical assistance so that we really improve the practice. Next slide, please. And this is some examples of the technical assistance that we can help provide. I think the biggest piece that, or inquiries that we get to our tribal affairs inbox from counties is help around ICWA's inquiry and noticing. And there is a lot of requests for sample protocols, policies around ICWA, because I know a lot of counties are doing that work right now. And so really there is some good examples that we have to share that counties are doing throughout the state. And really just making sure that any questions that there may be around the practice of ICWA or child welfare practices from either the tribes or county, that we're connecting them with the appropriate policy shop, our technical support, our resources. Next slide, please. And that it's just, that's a limited or a small list of examples, but really any request that we get, we try to work with you on making sure you get your needs met. And so another place to start when you are working with your tribes in your county is to take an inventory, who are your federally recognized tribes in your county, and making sure that they're included, and that you're making sure that it's being modeled from top down, because I know a lot of the issues that we hear really need the support of of management and supervisors to really make those changes that we need to improve the practice. And then be sure that when you are meeting with your tribes to engage with them, that you are providing more than one meeting time, letting them know why you're meeting. And I know Donald went through that as a really good way of just making sure that you're including them to work together. If there are no federally recognized tribes in your counties, see if there's any tribal resources available, but then also reach out to other roundtables that might be happening so that you can stay as informed about current issues that tribes are bringing to the table, so that you're making sure that you're addressing those in your practice, so that, again, you're being proactive and not reactive, so that when issues do arise, you already have a game plan and policy in place. Next slide, please.
So this is our draft TA process kind of flow chart of how it works. So if you county reps or your staff or you get a phone call, maybe you haven't engaged yet with our field liaisons, but you get an email or a phone call from our field liaison or one of us internally, it's likely because some assistance or a question or support has been raised by maybe one of your staff or even a tribe. And so we like folks to be prepared that it's not necessarily, we're not here as a I got you, that's not what we do. It's a how can we help you, or hey, we're getting questions around this, maybe we can help support some clarity. So what often happens is we get a TA request from a county or tribe, and then our OTA team will review it. And sometimes we bring in legal, depending on what the question is, and bring in legal to our review, not externally, because we're their client. And so we'll review together about the best course of action. And we usually, depending on the question, connect with the CDSS policy shop, because we don't necessarily make the calls, but we'll give advisement both externally, and we'll pull in somebody from the correct shop that needs to provide the clarification on an ACL or a specific area. And so together, often you'll get the email from both an OTA and whoever's policy area it is. And then oftentimes it's both coming together, and sometimes it might be one or the other, depending on what the question is. And we do track those TA requests because it's a way of, shoring up what the common gaps are, questions are, and it's also a way for our team to feel, to make sure they're tracking and be accountable to tribes and counties about the work that they're doing. A lot of this work and process has been developed through tribal consultation when OTA first began, and through the engagement. I know Sylvia was very involved and helpful with the development of when OTA first took off, and in that engagement with both counties and tribes. So a lot of what we do is grounded in tribal consultation and tribal values. And so the reason why I say this is draft, because we haven't finalized the adoption of this, and we will be here soon, but this is the usual flow. Next slide. So with that, and thinking about what OTA does, a lot of the work we do is we provide an overview and guidance on what ICWA is. We don't necessarily provide trainings to counties. We help pull in policy shops that do, but we give overviews of ICWA. We do Tribal Government 101. So we're going to give you some key areas and aspects of ICWA, and Sylvia's going to help me out here throughout this section. And it's important to know, I think sometimes we make assumptions that when you get a certain job title that you automatically know everything. And we know that for many folks, ICWA has been a gap in learning. And so there are a lot of opportunities to be able to, fill that. And it's more, I think, regular that leadership and doesn't necessarily know the key aspects of ICWA. So if you don't, you're not sure, please reach out. It's okay, because we see it all the time. And we know by the data and the numbers that there's a lot more education to do. Next slide.
All right. So the Indian Child Welfare Act, of course, is a very powerful act and very multifaceted statute. And so we're going to try to cover what are the important and salient parts for you as a child welfare leader. The ICWA provisions themselves address tribal rights and opportunities in child welfare cases, which would include any out-of-home placement in the delinquency court as well. There are minimum federal standards for all state court proceedings, and we'll be reviewing those minimum federal standards as well. And then there are Indian social and cultural considerations that are included as part of the Indian Child Welfare Act in terms of looking at services and resources that we're referring families to. So we really want to focus on understanding Native American culture and community, and utilizing services and resources that are natural for Native people, and not necessarily imposing those services and resources that are part of the dominant society or dominant culture, because they may not be the services or resources that that family is used to using, or that community. Next slide. So in the early 70s, there were some congressional hearings at the request of Native Americans who were experiencing unwarranted removals of children from their homes. And this was children still being removed, and adopted children still being removed, Native children being removed and sent to boarding schools. Congress had some congressional hearings, and these hearings revealed a pattern of wholesale public and private removal of Indian children across the board. And as a result of that, there were hearings that they had in which Native people testified as to what was happening in their communities. And Congress then, as a result of that, in 1978, passed the Indian Child Welfare Act. And the Indian Child Welfare Act was passed as a remedy to what was happening. It is a remedial act to remedy those abusive child welfare practices that were going on, and focused on prevention and focused on keeping the Indian child with the family. And as a result of the special relationship between the U.S. and the Indian tribes and their members, the federal responsibility that the government had to Indian people, Congress enacted the Indian Child Welfare Act. Now, the Indian Child Welfare Act, it really has two main purposes. One, to promote the best interest of Indian children, and to ensure the stability and security of Indian tribes and families. And these two are intertwined. What's important to keep in mind is the sustainability of a tribe, the sustainability of Indian people is dependent upon their children. If you take their children away from them, they will no longer cease to exist. And so the best interest of the child, the best interest of the community and the tribe is to maintain the child with the tribe, if at all possible, and to continue that connection and that relationship. So these two purposes are just intertwined with each other. Next slide. So Congress also found that states were exercising their jurisdiction over child custody proceedings through administrative and judicial bodies that often failed to recognize those essential tribal relationships and the connection that those children had to their tribe and their tribal community, to the extended family of the tribe. And they failed to recognize the cultural and social standards that prevailed in Indian communities and families. And so children were being removed for reasons based on what was considered appropriate for the dominant culture and not considering the social and cultural standards of the tribe. And so there were not necessarily abuse or neglect issues, they were just different social and cultural standards that were being ignored. So those findings really set forth two very important but distinct considerations that underlie the act and the federal best standard interest. And those were those two standards. The culture and concern for tribal heritage is relevant to proper application of the act. In order to ensure that you're really moving forward following the Indian Child Welfare Act and ensuring that children stay connected to their tribe and that the tribe is engaged in this process, one really needs to be looking at assessment, treatment, and placement standards that require adherence to the cultural dictates. And that is part of the law. So really you need to be looking at assessments that it's not just, we had this conversation the other day, not just focusing on the CANS assessment, but what other assessments that might be more culturally relevant that have been done or could be done that could be considered in this discussion. What treatments are available that might be more appropriate for the family and the tribe that we can provide. Then there's also the special services eligibility definition, which really reflects that common history that was suffered by Indian people throughout the nation. So these are two very important points. And the culture and historic ancestral tribal affiliations are relevant to the tribal membership and to compliance with ICWA. So it's important to ensure that we're looking at not just that connection, but also what's there in terms of the culture and their history that really ties them together and keeps us in focus of being in compliance with the Indian Child Welfare Act.
Sylvia, can I just add to that assessment piece?
Yes.
Really, another good example, since every county uses SDM, structured decision making, is ensuring that the tribe is part of that process, and your staff goes over SDM with the tribe, because how do you know, how can you check the definitions or the boxes if you don't know the tribe's community standards, or you haven't gone out together, or you know what the standards are for that community? And a very good example of that is many years ago, I worked with this individual a social worker who was incredibly kind, but he would often say, well, it's the tribe's standard. They all live in areas with junky cars, so it's not a safety issue. Even though that's not a safety threat in of itself, but was so applying the Indian community standards in such an opposite way, trying to be inclusive, that it minimized the tribe's concerns and worries. Because another comment would be, well, a lot of Indians smoke weed and do meth, so why I'm applying the Indian community standards? And the tribe said, that's not a cultural value or community standard. That's a part of historical trauma and ACEs. But why are you thinking that that's okay for us? That's why you need to ask us. So that's another example of, that assumption or putting your perspective without working with the tribe or including the tribe. So it can go either way, to minimize or to over synthesize what the issues are. And so using that assessment is really important in collaboration with the tribe. One might say, well, that takes too long. I have, it might be a 24-hour immediate response or a 10-day. Well, that's why building in protocols are so incredibly important. So you can be able to develop those key relationships, because how do you accurately assess if you're not in the community and you don't know the community standards? CDSS has completely been guilty of that, I will share. For all the times of SDM, tribes were never invited to be a part of, I think it's called the core work group, to recommend and make changes to SDM or updates. And so this is the first year in 2020 when tribes were invited to be a part of revisions or discussions. How do you have a tool that is used on Indian children and families, and the tribes aren't a part of the process? So trying to change those behaviors and model good partnerships. So it's a really good example. Thank you, Sylvia, for letting me butt in.
Thank you, Stephanie. All right, and so those are some really good examples. And the act also included tribal rights and opportunities in child welfare proceedings. And the jurisdictional provisions that they allow for are concurrent or exclusive tribal control over some cases. So their concurrent means that there can be a state, the state and the tribe at the same time are monitoring and working with that case. This is very prominent in California because of Public Law 280, or the tribe can exert exclusive control over the case. And then the case is entirely handled by the tribe. The cases can transfer to tribal court in some instances. The tribe can ask for transfer. The court can request transfer, but the parents can also not agree to transfer. So there are a lot of options that can be discussed, but the cases can transfer to tribal court. There is an opportunity for the sovereign entity to determine their own membership, right? So the tribes are the ones that determine membership. And that is very clear in the act, is that it's not up to the court or it's not up to the county. It's the sovereign's authority and right to determine their membership. And that membership happens when we do appropriate notice. They have the ability to regulate, which is license or approved placements for their members' children. And some have more authority in terms of just what they can do in that process. Some tribes can do the entire process. They can do the background checks and the home study and the training, all that's required. And some tribes usually work with counties to do a part of that. But they do have the ability to do that. They have the opportunity to reassume jurisdiction if they have not taken a jurisdiction in the past, or if they've turned it over and then they want to retake that back. They also, the orders must be given full faith and credit by the state court. So whatever happens in court and whatever, this is particularly evident in tribal customary adoption. You see the court giving full faith and credit to the tribal customary adoption order. So it's a court finding that they make where they honor the sovereignty of the tribe and the decisions the tribe is making in reference to the case. There are also agreements between tribes and states that are authorized in this process. In California, we see, once again, you see Public Law 280 in place. And so there's that concurrent jurisdiction. But the agreements also will allow for intervention rights by the tribe or by the state or by the county, depending on what that situation is. And the ability to alter the standards must be applied in state proceedings, whether or not the tribe intervenes. And so the tribe doesn't have to intervene in the case. The tribe can be just an observer in the case as it moves through the system. They can change their desire to intervene at any point throughout the life of the case. So they can start out as an observer, but then later intervene in the case, and even later in the case, they can take jurisdiction if they want. The act also is very clear about definitions of who is an Indian child, who's the tribe, who determines membership, those kinds of things. And the Indian Child Welfare Act has a very clear designation of placement preferences. There's an order of placement preferences for both pre-adoptive cases, so foster care placements, as well as adoptive placements. Those are all part of the act that were included in those congressional that congressional law. Next slide. You want to do this one, Stephanie? You want me?
Yes, I can do that. So those minimum federal standards, again, even though for state courts as child welfare agencies being arms of the court, it's important to know these components. ICWA does not apply to tribal proceedings unless adopted by a tribe by tribal law code. And there is an interplay of federal, state, and tribal law. They impose procedural how and substantive what requirements and apply to state court only. So apply whether or not the child's tribe intervenes, and Sylvia just talked about that, or otherwise involved. And I want to kind of share a note about that. Comments that we have to be careful of as being agents or professionals of a government, and making sure that we are inclusive and not passing judgment. If we think about when we shared about contemporary tribes and resources, where they are, each tribe is different based on a number of things. Sometimes I've heard staff, county representatives say things like, gosh, where's the tribe been this whole time? Now they want to get involved. And so those are the things we have to be careful of our team and our staff for doing this work, because there's various different reasons that we don't understand as county representatives, or don't fully understand or know about, or may not even have the right to know about. For instance, it could be resources or politics with even in the tribe that exist. And so, and maybe they didn't have staff, or there's one ICWA worker who's also the director, and they may have 200 kids throughout the state and can only be involved when they're able to. And so it's really important to know when to try to follow ICWA. You must follow ICWA, even if the tribe's not involved or intervenes. And then once they do, to do your best to partner and catch them up, because your course might change once the tribe intervenes. And that is honoring ICWA and tribal sovereignty. And that might be frustrating because a lot of work and resources and time has been involved, but who better knows their own people than their tribe or their community? And then, of course, assessments, which we talked about already, in the best interest of Indian children and stability and security of Indian tribes and families. So it's really important that assessments are used collaboratively. And then the other components, which are really key areas of ICWA, but the minimum federal standards for state courts and protections, inquiry, continuing duty in all cases from initial contact, using due diligence investigation when reason to believe. And so having standard form of questions that your staff ask. There's nothing worse than getting to an adoption or a 2-6 and having this not occurred. And then you get in a situation where I think folks want to argue bonding and the tribe hasn't even been provided the opportunity to be there. We do not want there to be another case, appellate case, and we don't want it coming out of California. There have been some already in California, but we definitely don't want to be in that spot. So we're here to help you if you don't know how to do this component or your staff aren't doing it. How are you as a leader making sure that this is being done properly from the get-go? So of course, it allows for intervention of both the child's tribe, parents, and Indian custodian, active efforts. And so efforts from initial contact to prevent the removal, and active efforts to be able to reunify as well. And so there are various types of active efforts, and you have to work with the child's tribe in order to determine what those active efforts are. You're actively engaging the tribe. You're actively providing those efforts and services to both parents and the child. There's evidentiary burdens. You must have a qualified expert witness at 2 points within the life of a case, depending on where you are with it. And then foster and adoptive placement preferences. So a word about placement preferences. The minimum placement preference is outlined within the Act. However, if a tribe has a different order of placement preference, it is the responsibility of the county to follow the spirit of that and to follow that. If the tribe has a different placement preference, that you should go with the tribes, it's recommended, rather than fighting with your interpretation of what the placement preference is. We've seen so many situations where it becomes a tug of war, and it plays out in court, and that ends up harming the child. When you think about resources, you think about tribal sovereignty, you think about inclusion, and Indian community standards. If you are finding that your staff or your agencies consistently fighting with the tribe on placement preference, we advise to take a deeper dive and to look at, if you think about practice behaviors, why is that? Why are we so far away from what the tribe's recommendation is? And why are we going in a different direction every time? What are we missing? Or what are the standards or the cultural values that we don't understand? And how might we be closer together? So it's really important, as far as if you think about the intention of the Indian Child Welfare Act, to keep families and tribal communities and children, there as a part of their tribe. And a good example, sometimes the tribe might recommend somebody that you would never think foots that bill, but it's the tribe's assessment to make that determination in that call. And so thinking about that is critically important. And then it also adopted Indian child's right. Invalidation of proceedings is another component of it. And then higher state or federal standard of protection to rights of parent or Indian custodian applies.
So in addition to the federal law that's been around for 43 years to protect Indian children, California also took that extra step to say, this is going to be also a state law. And California law recognizes that there's no resource that's more vital to the continued existence and integrity of Indian tribes than their children. And the state has an interest in protecting Indian children who are members of or are eligible for membership in an Indian tribe. And again, the state is committed to protecting the essential tribal relations and best interests of the Indian child by promoting practices in accordance with the Indian Child Welfare Act. This includes assisting the child in establishing, developing, and maintaining a political, cultural, and social relationship with the child's tribe and tribal community. And when you couple that with Gavin Newsom's Truth and Healing Commission that he assembled, you want to get to the core of why we are not doing ICWA as a state. What is going on? Okay, we have these laws. Is it lack of resources? Is it what's going on systemically that is happening that we all can get together to figure this out? Because for far too long, there have been some missteps. And what can we all do to come together to figure this law out, which is the gold standard of social work, which not only helps Indian children, but all children. So it gets complicated though, because we have these different definitions and we have these different rules that apply. And as someone coming from a non-federally recognized tribe, I definitely want to promote the spirit of the law, because some of us don't have our paperwork in order. We're not able to be protected under the federal law. So in the next slide, Stephanie's going to talk further about how complicated these little definitions can be and hopefully shed some light onto that. Thanks, Steph.
Yeah, so it, as Donald said, it does get complicated in California, particularly around eligible Indians. There's specifically outlined of how the law, how we are to provide services to eligible Indians. And so an eligible Indian is any member of a federally recognized tribe or any descendant of an Indian who is residing in California on June 1st, 1852, but only if such a defendant is living in California and is a member of an Indian community served by a local program of service and is regarded as an Indian by the community by which such descendant lives. Any Indian who holds trust interest in a public domain, national forest, or Indian reservation allotments, and any Indian in California who's listed under the plans of the distribution of assets. So I say this kind of jokingly, but it's not a joke. This is how complicated it is to be an Indian or be recognized as an Indian in order to protect your children or your community or your standards. So there are some allowances, but it's complicated. Just know that, and we're here to help you sort those out if your team isn't quite sure of what that looks like. So the summary of this is collaborate early and throughout, and apply the spirit of the law. Next slide. And just know that California took it very seriously, as Donald said, the importance of ICWA and codified ICWA starting in 2006 with what we know as SB 678. There have been numerous updates since then and specifics to pay attention to. It outlined the spirit of ICWA and as well as inquiry in all cases, and it just actually, relanguaged what was federally there. And then we'll hear a little bit more next about AB 3176, but that was in 2019, where it conformed California law to amended the 2019 federal ICWA regulations. And Sylvia will cover that a little bit more on the next slide. But then also in, I think it was probably 2016, or there was a WIC amendment for CDSS to enter into 40 agreements with tribes. And then in 2016, ICWA integrated throughout the regulations. And then the use of tribal services for Indian child placement and health and safety codes, RFA written directive for tribally approved homes. Also the retention of Indian child placement records in perpetuity, and then tribal background check option for tribes and health and safety codes. So as you see over this last probably 10 to 15 years, a lot more efforts to make ICWA apply and accessible and to be in alignment with respecting tribal sovereignty and to also attend to better outcomes for Indian children.
All right, so in 2016, the Bureau of Indian Affairs updated their regulations to provide some clarity around issues that were unclear across the nation in regards to ICWA. And this change resulted in Assembly Bill 3176 for the state of California that came out in 2019. And that was to update the outdated information. So there were some really important things that came about as a result of AB 3176 that now new social workers who are coming in new to the agency are learning about these things in the core ICWA training. So active efforts was clarified to reflect that it's more than required in reasonable efforts. And so really a clarification that reasonable efforts was for any case that was a non-ICWA case, and that active efforts is really more than what is required in a non-Indian case. Sorry. And so they defined active efforts, active, thorough, timely. So meaning that the person that is helping provide those services is actively engaged and actively helping the folks who need to be helped throughout this process. So it's not just giving them a bus pass to get on the bus. It's asking them if they know how to get on the bus. And if not, how do they, where going with them and teaching them how to use those things. It's a very active on the part of the social worker in this case. It also clarified reason to know a child is an Indian child, which was actually narrowed from California's very expansive definition and added a statutory presumption that ICWA standards apply if there is reason to know. So right now, what we have now is, and this was mentioned in the previous slide, reason to believe and reason to know. Reason to believe means the social worker must do more inquiry. So they have some information that says the child may be an Indian child. Many times as a social worker, you hear, oh yeah, I think my great-great-grandma was, Cherokee or Choctaw. And then, so that's reason to believe because somebody has said something, but we really need to, we can't just notice every Cherokee and Choctaw tribe. Now we have to find out more information and get more specific. So we need to do more inquiry. The burden is on the agency to do more inquiry to try to get more specific information so that they then can appropriately notice. And reason to know is when you have information that actually tells you who the tribe is and what the location of the tribe is and what the relationship is. You might have an enrollment number Or you might have grandma who has an enrollment number, but the parent is not yet enrolled and the child. So then you have reason to know, and then you can notice the tribe. So they clarified that for the act in AB 3176. And then child custody proceedings were clarified so that a hearing is really known as a proceeding, and where ICWA applies is determined by the possible outcome of the hearing, meaning that those proceedings are either foster care or termination of parental rights or a pre-adoptive or adoptive placement. So those are now known as proceedings. And the voluntary proceeding was clarified in that an Indian child can be placed, a parent can place their child without the threat of removal from the agency. They can voluntarily place the child if they need to do that, and then they can get the child back when they request the child, and that the agency cannot interfere with that voluntary proceeding. That's a right of the parent to do. The emergency proceedings consist of the detention hearing happening within 30 days of the emergency removal, with a finding that the removal was necessary to protect the child from imminent physical damage or harm. That would be very similar to any other case, but the hearing must happen within those 30 days. It clarified county and state actions to determine tribal exclusive jurisdiction and how to properly handle those cases in which tribal exclusive jurisdiction exists. So it made it clearer for judges and courts and attorneys and social workers around that. Clarifies that inquiry begins at very initial contact. So I know in my own experience, I would hear all the time emergency response workers saying, well, ICWA doesn't apply to me because I'm just doing the investigation. And so this clarified that no, you need to be asking as soon as possible, preferably at the hotline. Those questions are being asked, as was said earlier, and continually throughout the life of the case, and that it begins as soon as you have contact with that child. And we talked about the difference between reason to believe versus reason to know. The child is an Indian child. And also it clarifies when the full ICWA versus standard notice is required. So those were major changes that happened as a result of 3176. All right, so this is just a flow chart of the difference between the reason to know and the reason to believe. And this is, there is a draft ACL that's going to clarify this because this is causing a lot of heartburn in California. So when there's initial contact, the child and family are disclosing to the social worker, to the probation officer, in their duty to inquire, they're disclosing, yes, we may have some Indian heritage. And so their duty is to conduct additional inquiry and to get those specific information. So asking questions. There's some counties that have developed different kinds of questions to ask instead of just asking, well, are you Native American? Or do you have Native American ancestry? It's like, well, who in the family keeps the history for your family? Is there someone in the family or somebody that we can talk to that might know this information? Is there a tribal representative that might have this information? It's supposed to be, it's just very asking a lot of questions and getting to more information that you want to gather so that you can then move to reason to know. So once somebody says yes, you can contact this person and that person is able to give you names or date of births or enrollment numbers or tribal individuals that could be contacted that can confirm information. Then you might have reason to know and you move on to complete your inquiry, get that information and complete the appropriate documents. In our case, it's the 030 that we would complete and send as notice to the tribe, and then wait for the to the tribe to respond. One of the things we're always telling new social workers as they come on board is don't just wait for the tribe. Don't send your notice out and wait for the tribe to respond. You've heard Stephanie say tribes have different resources. Sometimes they have more resources than others. I get to train tribal social services folks through the National Indian Justice Center. And in one of my courses, I had an individual from the White Mountain Apache tribe, and she was the only noticing person for her entire tribe. And she said she received about 1,500 notices a month. And so she's one person who's going through 1,500 notices a month. She says she's working all the time trying to respond to those notices. But what she did say is if you email her or you call her, she can respond much quicker than just waiting for her notice. So your active efforts are really working with the tribe to try to get that information. You don't just send the notice and then sit and wait. You actively participate in trying to secure that information so that you can then report that information to the court. And Stephanie, somebody asked, do you know when the draft ACL is supposed to be sent out?
We are reaching out right now to find that out for sure. But right now it's with tribes for review, for tribal consultation or review. And I believe after the tribes comment period, then it will go out to stakeholders. I'm waiting to confirm that though.
Okay. All right, next slide. Did you want me to talk about this, Stephanie?
Go for it.
Okay. So as you can see at the top of this slide, complexity plus diversity plus change plus unfamiliarity really leads to difficulties, frustration, and a lack of compliance. So that's part of why we wanted to talk about this today, right? So that it's important to understand that across the board in California, the number one reason for appeals in California are around ICWA notice. So the California Judicial Council analyzed a period of time in 2015, July through October, and 30% of all the dependency appeals were ICWA appeals. 85% involved ICWA inquiry and notice. So that's off the top, a huge percentage that's just around inquiry and notice. 70% resulted in some form of remand for ICWA compliance. So there was a failure to notice and something happened as a result of that because it was appealed. The Indigenous Law and Policy Center of Michigan State analyzed 2017 data, and in 2017, there were 214 appealed ICWA cases, which was up 39 from the prior year. There were 34 reported ICWA cases, and California led the states with 152 cases, 5 reported, and Alaska was second with 6 and 3 reported. So California definitely has an issue with this. And it's important because, as Stephanie said earlier, it impacts the child. We had a case in particular that was moving through the dependency process. It got all the way almost to the 2-6 hearing when a father appeared, because we didn't do good notice. The father appeared and the father was Native. And that case, I mean, that child was a month away maybe from permanency, and they had to start that process all over because of that. So it's important that we're not hurting children because we're not doing our job and we're not in compliance. So there was also a 2017 tribal task force on ICWA compliance. And there's the California Attorney General Bureau of Children's Justice that did some investigations and lawsuits against California counties in Northern California for these reasons, for this lack of compliance on ICWA and the failure to meet the standards of the Indian Child Welfare Act. So why do you guys think ICWA implementation is so challenging in the counties? Why do we think, what are some thoughts around You could unmute yourself or put things in the chat. We would love to hear from you guys because you're out there doing this work. Why is it so challenging? Why is implementation so difficult? Anybody?
And this really helps us to help you all.
So I think for our county specific is we don't, even though, sorry, we don't do a,
Take your time, Morgan.
sorry, dry throat.
Uh-huh. Anybody else while Morgan is stopping himself from having the trouble?
I apologize about that. Yeah, I don't know why my throat got sore. Well, for us, I think we don't do a lot of it. And so knowing what questions are the right questions to ask, I have found is one of the just issues where a lot of social workers are getting hung up on ancestry versus, so the reason to believe questions versus the reason to know questions. So they'll ask about ancestry, but they won't probe a little deeper to ask about eligibility or membership, and learning really how to navigate those questions well is one. And I think the other ones systematically is what we're finding is tribes, since they're sovereign, all do things differently. So one tribe might respond to emails when reason to believe, when there's reason to believe. So when further inquiry is needed, and other tribes will want a more formal letter through certified mail. Other tribes will be okay with the phone call. And so it's it's figuring out how to navigate when there's no standardization of communication on reason to believe specifically, because reason to know, we know, okay, we can do an 030 notice once we have enough information to really give the tribes enough information to make make their determination. So I think that's it. And I've even found, I think even with the tribes, you know, what you talked about, it's them being overwhelmed. We've done 030 notices where we've specifically spoken to the tribes and they said, yeah, the child's eligible, which prompted us to do the 030 notice. And then we've had tribes respond with, oh, the child's not eligible. And it was just because they're so overwhelmed and inundated with all these requests that they don't then catch the full 030. So they may just look at, we've been told by certain tribes, they're just looking at parent and child's relationship, not necessarily all of the ancestry. And so I think there's just a lot, especially, you know, with COVID now and they're being impacted with who's at the tribe and their numbers and who can help out. And that's what we're running across, at least in our county.
Mm. All right. Well, I think one of the things I do know is that the OTA field liaisons had worked with some of the counties on developing some questions as guidelines for counties to share with their workers that they could use to really do more of that inquiry, so that just some questions that would help guide them. So that would be one thing that your OTA liaison could probably help you with. And then I think also with the noticing of tribes and some of those issues, if you know, it's how can the Office of Tribal Affairs help with that? Think about that. Is there a way that they could facilitate some dialogue with the tribe that would figure out a way that you guys could work together to have conversations about those? I do understand the resources are different. But I don't want us to see that as an excuse. So if this child was in another country, all of the countries would have different processes and policies as well about how they handled it. And so that's how we have to think about it. It's, you know, if we have a child that's from Germany, their processes aren't going to necessarily be the same as a child from Mexico. And so we have to adjust our system or our processes in order to meet theirs so that we're doing what's in the best interest of the child. And that's the same for the tribes. I know that would be, you know, it just adds to the, somebody in the chat said something about the workload and the work. We understand that the workload is what it is. So, well, Stephanie and I were both child welfare directors, but we cannot ignore the rights of Indian people and Indian children because our workload is too much. Judy, you have your hand up.
Yeah, hi. I was trying to think of how to say this, but it has to do, and I'll qualify by saying I have not gone to any of the more recent core trainings, but the idea of integrate, you know, I don't know how to say it. It's how do we formulate the tasks into the larger construct of practice? Maybe that I'm starting to get to it there, because in practice, you have a mental map and you oftentimes are starting with the end in mind, so to speak. And so to that point, you know, our end result, we really need to be changing the way that we are teaching our social workers, because right now we're teaching that adoption or guardianship is equal to reunification. And I would like to just be more explicit about having reunification be the you know, a prize, and in that context, then all the practice that we do should be in service to keeping children with their family or with their community. So how do we begin to change the way we're training social workers? Because when I hear workload, I hear tasks, because I, you know, delve down into conversations with my staff, and they are very task-based. And if we don't begin to heighten and develop the practice for them, then it's just going to continue to be task-based, and they're going to keep seeing this ICWA issue, among other issues, you know, CFTM, CANS, et cetera, as just something else they have to do, and not within that larger tapestry of practice. And I don't have the answer to it. It's just been something I've been thinking about.
Yeah, and I think that speaks to part of the work that we need to do around the core practice model, right? Is how do those behaviors help us to change the focus that workers have from task to really focusing on, it's not about the task, it's about how I work with people, it's about what I do with them and how I engage with them, how I engage with the family, how I engage with the child, how I engage with the tribe, to really listen and hear and communicate in a way that really is creating a relationship so that you're moving forward. It's focused on it's how we behave. It's not about the task that we have to do, but it's really about what our behavior says we should be doing. So really integrating these core practice model behaviors into talking about that, right? How do we do better inquiry, right? We're really, I think Dana put in there, how are we engaging? How are we exploring?
Yes.
What are we doing with the family? Yes. So it's really about
practice is about the therapeutic relationship. And we just need to be saying that more explicitly. I say that to my staff and they look at me like I'm speaking Greek. Not all of them, but some of them.
Yes. So if you see on the slide, implementation and training approaches have really set the bar too low, often focusing on ICWA eligible, and counties are really ill-equipped to engage with tribes as governments, for one. And so, but we really need to be focusing on that behavior. How does that behavior help move us forward in terms of the core practice model? We just really need to figure out how do we work through that and begin to develop those relationships, because even with each other, you know, if you think about you guys as child welfare directors or child welfare managers or supervisors, you can create a team that works together to be able to get the work done, to be able to accomplish what you need to accomplish. And it's about the behavior that you have with each other that moves that forward. And so that's how we have to focus on it.
And I realize we're running pretty out of time. We have about 3 more slides left, so thank you for sticking with us. This is some data information that the field liaisons gathered when we were building our ICWA strengthening survey that had a lot of help from the Capacity Center Building for States. We sent this survey out to county directors and ICWA points of contact, as well as tribal directors. And part of the qualitative data that came out was some of this, that shares that the barriers on the tribal side, they recognize high caseloads, resources, high staff turnover. County side, same thing, high referrals, high turnover, lack of resources. This really long quote, I recommend you check that out later on. That kind of summed it up perfectly as why there are these issues here. But it's good to recognize these barriers so we can do something about them now. So now that we know, what are we going to do? So what is our path forward? And that's on the next slide.
So we have a lot of responses from many of those surveys and from many of you. What our goal really is to, how do we put this up in the forefront and center, the relationship, and working on it as a commitment and better understanding, as well as when you come to the next session, we're going to share some strategies, not only about the practice behaviors coupled with strategies. And so, you know, you got to hear some of the basics, and some of you presented some of the barriers. We'll probably explore those barriers more so in our next session, as well as sharing some tools and strategies, very specifics that you as a leader can employ to attend to some of this. Not that we have all the answers, but as a team, we have some ideas, and we definitely know of some counties and tribes who have figured out some ideas and solutions as they shared their work today, and some other strategies as well. Go ahead and go to the next slide. And then if Sylvia, if you want to help us wrap this up and talk about our next 2 sessions.
All right, so thank you everybody for your comments today and your participation. The panel was excellent. We appreciate your attention today, and we are building a final session that we're planning for January, probably the end of January. But in between, we will have a 2.5 session like we did in between the first session and this one. We had a 1.5. That we're hoping that those sessions, once again, will be facilitated by the RTAs with the directors and occur prior to the next session. They're going to really focus on the county's designation of their ICWA points of contact that were designated by each county, and have some discussion around the role of the points of contact and some of the responsibilities that they have, and then revisit the ICWA data that we asked directors to pull and really start talking about strategies for action. And those will be done with their OTA liaisons, who you've had the pleasure of hearing from today, so that they can work together as counties and the OTA liaisons in really diving down deep into that data and identifying strategies for really working to improve the ICWA compliance around those important issues and important pieces of the act. And then our final webinar is really going to focus on the leadership behaviors from the core practice model and how those can work to support working with tribes and support the implementation of the Indian Child Welfare Act. And we'll try to focus on all those behaviors in terms of just what are some strategies. So we're looking forward to our next session. You guys will have the 2.5 between now and that session, which will be most likely at the end of January. And that's it for today. We thank you for participating and for being with us today.